a 5-year-old girl, a 3-year-old boy, an 8-month-old baby. On a January evening in Duxbury, Massachusetts, all three were killed inside their own home. A state trooper, sweeping his flashlight across the dark backyard, saw two adults outside, one on the ground, one standing over them. Minutes later, in the basement of that house, a father looked up at the officer in the doorway and screamed 4 words. "She killed the kids." Those 4 words are the reason you already think you know this story. They are the reason it made national news within hours, the reason strangers overseas have watched the trial livestream, the reason a courtroom in Plymouth County has spent weeks working through testimony that most people would rather not have to imagine in any detail at all. It's worth pausing on that livestream detail for a second, because the fact that ordinary people anywhere in the world can watch a murder trial unfold in close to real time is a genuinely recent development, and it's part of why a case like this can dominate the public conversation the way it has. Cameras in American courtrooms are a relatively modern, and still not universal, practice. Plenty of states and federal courts still heavily restrict or ban them outright. Massachusetts is one of the states that generally allows it, subject to a judge's discretion, and outlets built specifically around gavel-to-gavel trial coverage have existed since the early 1990s, expanding dramatically once that coverage moved from cable television onto the internet, where it could be clipped, shared, and picked apart in real time by anyone watching from home, rather than filtered entirely through a nightly news broadcast. A trial covered this way stops being something you read a summary of the next morning and becomes something you can, in effect, sit inside, which is part of why the emotional pull of a case like this feels so different from how the same facts would have landed on the public 20 or 30 years ago. It's worth understanding briefly how outlets built around this kind of gavel-to-gavel coverage actually operate as businesses, because it explains why a case like this gets the specific kind of treatment it does. Networks and platforms dedicated to full trial coverage generally position themselves as a more complete, less editorialized alternative to a traditional evening news segment. The pitch, essentially, is that instead of getting 90 seconds of the day's most dramatic soundbite, a viewer can watch entire witness examinations unfold in real time and draw their own conclusions from the full context, not a producer's chosen highlight. That model depends on genuinely sustained viewer attention across a case's full length, which is part of why these outlets tend to invest heavily in dedicated legal analysts and reporters who follow a single trial from opening statements through verdict, rather than parachuting in only for the most dramatic days. It's a meaningfully different economic model from a viral short-form clip built to be watched once and shared, and it's part of why the material this video draws from, full witness testimony, complete cross-examinations, extended legal analysis, exists as thoroughly and as accessibly as it does for a case like this one. It also means the raw material for online theorizing, every hesitation in an answer, every inconsistency in a timeline, every awkward pause on cross-examination, is available to literally anyone with an internet connection, in a way it simply wasn't for earlier high-profile cases that the public only ever encountered through a reporter's condensed account of what happened that day. But the 4 words a father screamed in a basement in the worst moment of his life are not the whole case. They are the opening line of it. What happened in that house and what has happened in that courtroom since is longer, stranger, and harder to sit with than 4 words can carry, and it is worth walking through slowly in order, using only what has actually been said under oath, rather than what has been said online. The woman on the ground that night was Lindsay Clancy. She was 32 years old. She had been a labor and delivery nurse, the kind of person whose job, for years, was to be in the room at the exact moment new families began, to hand a newborn to an exhausted parent and watch that parent's whole face change. There is a version of this detail that gets repeated online as though it were itself evidence of something, the idea that a nurse, of all people, someone trained around exactly the kind of medical crisis she was allegedly experiencing, should have recognized her own symptoms and gotten help before it went this far. It's worth being careful with that instinct, because it rests on an assumption that doesn't hold up well against how postpartum psychiatric illness actually functions. A labor and delivery nurse's clinical training centers on childbirth itself, the physical process of delivery, newborn care, postpartum physical recovery, not on diagnosing psychiatric illness in herself while she is, by definition, in the middle of a break from clear thinking. Plenty of physicians, including psychiatrists, have written and spoken publicly about how difficult it is to recognize a mental health crisis in themselves, specifically because the illness itself distorts the very judgment a person would need to catch it early. Professional medical knowledge doesn't function as a shield against a person's own brain failing them. If anything, it can make the eventual reckoning crueler, because it adds a layer of self-blame, the sense that you of everyone should have seen it coming on top of an illness that, by its clinical nature, is specifically built to make sure you don't. By January 24, 2023, she was a mother of 3 herself. A 5-year-old daughter, Cora. A 3-year-old son, Dawson. An 8-month-old baby boy, Callan. She was also, by every account given in that courtroom since, at the center of the worst month of her own life, one that had been building for a while and that nobody around her, not her husband, not her doctors, not her own family, had managed to catch in time. On that Tuesday evening inside her own home, Lindsay Clancy used exercise resistance bands to strangle her 3 children. Afterward, she cut her own wrists and throat, swallowed a large quantity of crushed medication, and climbed out a second-story window, falling to the ground below in an attempt to end her own life. She survived. She is paralyzed from the waist down because of that fall, and she has been for the 2.5 years since, meaning that for every single day of this trial Lindsay Clancy has sat in that courtroom in a wheelchair, listening to witness after witness describe, in clinical unsentimental detail, the worst night of her life, in a body permanently and visibly altered by her own attempt to end it. That physical reality tends to get flattened into a single clause in most coverage of this case. She is now paralyzed. But it's worth sitting with what it actually means day to day, the loss of independence that comes with it, the medical complications that often accompany a spinal injury of that kind, the fact that whatever the jury ultimately decides, whatever sentence or commitment follows, she will be living the rest of her life with a permanent physical consequence of that January evening regardless of the legal outcome. That doesn't change the legal question in front of the jury, and it isn't offered here as an argument for leniency. The law doesn't weigh a defendant's own injuries against the harm done to victims, and it shouldn't. It's offered because it's a real physical fact about the person this case is actually about, one that's easy to lose entirely underneath the theories, the timelines, and the courtroom procedure. None of that is disputed. Lindsay Clancy's own defense does not deny that she is the one who did this. What is being argued in that Plymouth County courtroom right now is not whether she killed her children. It is whether, in the eyes of the law, she is criminally responsible for having done it, whether because of a severe mental break, she was capable at that moment of understanding right from wrong. That is the entire legal question at the center of this trial. It is also, whether anyone intends it to or not, the question the internet has turned into a much bigger, much messier argument about who is really to blame. It's worth slowing down on that basement scene for a second, because the testimony behind it is more detailed than the 4 words alone suggest, and the detail matters. The trooper who first crossed paths with Patrick that night testified that as he came around the side of the house, he could see 2 figures near the porch and deck area, one lying on the ground, one standing over it, and that he began making his way toward the far end of the house, past what he described as the father's furthest right windows, illuminating the yard with his own flashlight because it was already dark. That's when Patrick crossed his path near a bulkhead entrance on the side of the house, moving quickly, a cell phone visible in his left hand down by his side, saying nothing as he passed and heading up toward the deck. The trooper testified he didn't know at the time what he was walking past. Just a man moving fast and abruptly in the dark. Minutes later, he and another officer heard screaming coming from inside the house. They made their way back around toward the deck, entered through the kitchen, and could still hear the same screaming as they came down the basement stairs, a stairwell that, according to testimony, has a photograph of Lindsay and Patrick hanging at the bottom of it, and that splits into 2 separate rooms once you reach the bottom, one to the left and one to the right. The screaming was coming from the right side. That's where they found Patrick, in a back room past a cluttered front room, and that's the moment he cleared the door frame and screamed the 4 words this story opened with. Once he cleared it, officers testified, they could see into the room behind him, and that's when they first saw one of the children. The 911 call itself came later than you might expect, and Patrick was asked about that gap directly on the stand. He testified that he didn't know the exact time he called, only that it took a few minutes to actually connect, because his phone kept switching between Wi-Fi and cellular service, enough of a delay, he said, that he nearly gave up and started shouting for the neighbors instead before the call finally went through. According to a release from the district attorney's office, that call was logged at 6:11 p.m. Camera footage separately places Patrick leaving the 3V restaurant at 5:54 p.m. That's a 17-minute gap between the last confirmed public sighting of him and the moment he called for help, the same length, coincidentally, as the earlier gap between his 3-minute drive estimate and his actual CVS arrival, though this second 17 minutes has drawn none of the same online scrutiny, for a simple reason. It's the one stretch of that entire evening with an obvious, undisputed, non-sinister explanation. A drive home from the restaurant. Walking into a house that from the outside would have looked completely normal. Whatever amount of time it actually took him to realize something was wrong, find his way to that basement, and process what he was looking at, before his hands were steady enough to dial and his phone had finally found a signal. 17 minutes is not a long time to drive home, walk in, discover the unthinkable, and then physically manage to call for help. If anything, given everything that had to happen inside that window, it reads as a plausible, even fast sequence of events, not a suspicious one. It's worth noticing that distinction because it's the same category of gap in the timeline that fueled the doppelganger theory a few minutes earlier in this story, and here, with a fuller picture of what actually filled it, nobody has ever suggested it hides anything at all. The difference isn't the length of the gap. It's whether you have the full context around it before deciding what it means. Before we go further, it's worth being honest about something. This is a hard case to sit with, and it has become, over the last several weeks, one of the most discussed criminal trials in the country, not just because of what happened, but because of what people online have decided might have happened instead. There are theories now that Lindsay's husband was somehow involved. There are theories that she faked her own mental breakdown. There is even a theory involving the man who currently owns their old house. Some of this stems from real inconsistencies in testimony, the kind that happen in almost every trial and that lawyers are trained to press on. Some of it stems from people who have never opened a single court transcript deciding that a tidy, familiar plot twist is more satisfying than a genuinely difficult truth. And some of it, honestly, stems from the sheer difficulty of the real explanation on offer here. A documented, clinically recognized psychiatric emergency that the people around Lindsay Clancy, including trained medical professionals, didn't fully catch in time, ending in the deaths of 3 children with no single villain to hold responsible for the outcome the way a conspiracy would let you. That version of events doesn't resolve into anyone being punished for a cover-up, doesn't produce a satisfying reveal, and doesn't let anyone walk away from this story feeling like justice, in the simplest sense, was done to the actual cause of what happened. It just leaves you with a tragedy that was, by the fullest reading of the record, close to unpreventable in the moment it occurred, and preventable only in hindsight months earlier, by systems that didn't catch what was building. That's a genuinely harder story to sit with than any of the theories built to replace it, and it's worth being honest about that difficulty rather than pretending the real version is somehow more comforting than it is. We're going to go through all of it today, theory by theory, using the actual testimony instead of the algorithm's version of it, and if you want more cases broken down this same way slowly from the actual record without the shortcuts, this channel does that every week, and subscribing is the easiest way to make sure you don't miss the next one. To understand why any of these theories gain traction at all, you have to start with the timeline of that evening because the timeline is genuinely strange, and strange timelines are where conspiracy theories are born even in cases with no conspiracy in them at all. Patrick Clancy, Lindsay's husband, has testified that at around 5:15 p.m. that evening, Lindsay texted him. It was a mundane message. She needed him to pick up Pedialyte, the children's electrolyte solution, on his way home, the kind of text a tired parent sends another tired parent 100 times a year without either of them remembering it afterward. Patrick has testified that he left the house sometime around when that text came in, took a direct route out the driveway, right on Winter Street, left onto the main road, and drove straight to the CVS in Kingston, a neighboring town just across the line from Duxbury, the kind of short, ordinary hop between 2 small South Shore towns that residents of that stretch of coastal Massachusetts make constantly without thinking twice about it, the same way someone might describe driving into the next town over for a specific store rather than treating it as a real trip. That geography matters a little for how you should picture the errand itself. This isn't a highway drive across county lines. It's the kind of short, familiar hop a parent might make several times in an ordinary week, unremarkable enough that neither Patrick nor Lindsay had any reason to think twice about the route, the timing, or who might one day be scrutinizing it minute by minute. He testified under oath that the drive takes about 3 minutes. 3 minutes. If he left at 5:15, or even 5:18, basic math says he should have been parking at that CVS by roughly 5:20 at the latest. The store's own security footage, however, does not show him walking through the doors until 5:32 p.m. That is somewhere between 12 and 17 minutes he cannot fully account for. between a 3-minute drive he described himself and the moment the cameras actually catch him arriving. It gets stranger. There is an email, entered into evidence as an exhibit, sent from Patrick's account to his co-workers at 5:24 p.m. that same evening, squarely inside that unaccounted-for window. On the stand when he was first asked about it, Patrick said he believed it had been sent from what he called his Surface Pro, his laptop computer, physically inside the house. Then, a moment later on the very same line of questioning, he corrected himself and said he actually wasn't sure, that it might have come from his iPhone instead, which would mean he was already out of the house, likely already in his car when he sent it. Prosecutors pressed on this hard, walking him minute by minute through the discrepancy. The text at 5:15, the 3-minute drive he'd already testified to, the 5:24 email, and the 5:32 arrival on camera. Under that questioning, Patrick's answers became noticeably less certain. "I don't know," he said more than once when asked directly whether he could have been sitting in his car, phone in hand, during those missing minutes rather than already inside the pharmacy. It is the kind of exchange that, read cold off a transcript, looks like exactly what internet sleuths have decided it is, a hole in the story. Read in context, though, it looks like something far more common and far less sinister. A man testifying under oath in numbing detail about the single worst evening of his life, more than 2 years after it happened, trying to reconstruct minute-by-minute movements that he had no reason at the time to memorize, because at the time they were nothing. A drive to CVS. A stop for dinner. The kind of errand you forget the instant it's over. Right up until the moment it becomes the most scrutinized 17 minutes of your life. That 17-minute window matters for a specific, grim reason, and it's worth pausing on the actual mechanics of it, because this is where some of the most serious "was it really Patrick" theories come from. Security footage places Patrick entering the CVS at 5:32 p.m. Separate footage places him leaving a restaurant called 3V at 5:54 p.m. That's a 22-minute stretch between two confirmed sightings, 17 minutes of which, by some tellings, would need to have been spent doing something else entirely for an alternate theory to work. Medical examiners testified that Cora and Dawson's estimated time of death fell somewhere between 5:15 and 6 p.m. separately. An expert testified that death by strangulation typically takes somewhere between 6 and 8 minutes to occur. Do that math across 3 children rather than 1, and you're looking at something in the range of 18 to 24 minutes required just for the act itself, without accounting for anything before or after it. Set that against a father who has security camera timestamps placing him inside 2 different retail businesses, on 2 different sides of town, bracketing that entire window, and the physical logistics of him having also been the one inside that house doing this become close to impossible to reconcile, not theoretically but literally, on a clock. This is the actual, sourced version of what online commenters have flattened into. The timeline doesn't add up. The timeline genuinely is a little odd. It is odd in a way that a defense attorney or a true crime commentator can reasonably ask questions about. It is not odd in a way that leaves room, once you actually look at both ends of it, for Patrick himself to have been the one home committing the murders. It's worth actually sitting with that 18 to 24 minute figure for a second, because a number like that can slide past you in a sentence without registering what it actually represents. 6 to 8 minutes, per the testimony, is roughly the length of time it takes to prepare a simple meal from a box, or to wait through 2 full commercial breaks, or to sit through a short guided meditation. Now multiply that by 3 separately for 3 different children, one right after another, with no gap between them long enough to be meaningfully called a pause. That is the physical span of time the act itself required, according to expert testimony, set against a father who has 2 separate, camera timestamp sightings of him on the far side of town bracketing the entire window on both ends. It's not a small discrepancy you can round away. It's the difference between a theory that sounds plausible in a 2-line comment and a theory that has to survive being laid directly against a clock, in minutes, with witnesses and store cameras on both sides of it. It doesn't survive that test. That's not a matter of opinion or of trusting the official story. It's arithmetic applied to numbers that came from sworn testimony and unaltered surveillance footage, not from either side's closing argument. It's worth knowing as general background, roughly how a medical examiner actually arrives at a window like between 5:15 and 6 p.m., rather than a single precise moment, because true crime audiences sometimes assume forensic science can pin down time of death far more exactly than it actually can. Estimating time of death is not an exact science even under ideal conditions. Examiners work from a combination of factors that each carry their own margin of error. body temperature decline, the onset and progression of rigor mortis, lividity patterns, stomach contents relative to a known last meal, and, when available, corroborating circumstantial evidence like the timing of phone activity, witness accounts, or, as in this case, a documented text message sent from inside the home. Combining several of those methods narrows the estimate, but it essentially never produces a single exact minute. A 45-minute window, as testified to here, actually reflects a fairly tight, well-corroborated estimate by the standards of the discipline, not an unusually vague one. It's also why the strangulation time estimate, 6 to 8 minutes per instance, matters as much as it does to the overall logistics question. Unlike a stabbing or a gunshot, which can end a life in seconds, manual or ligature strangulation is a comparatively slow mechanism of death, requiring sustained, continuous pressure over multiple minutes, which is part of why medical experts are able to speak with more confidence about how long the underlying act itself is physically capable of taking, even without knowing the precise minute it happened. There's another piece of context worth including here, difficult but relevant to how you should weigh the physical logistics. Expert medical testimony in cases like this typically distinguishes between the act itself and the broader window in which a perpetrator would have needed to be present in the home, including whatever led up to it, and whatever happened in the immediate aftermath before anyone else arrived. That's part of why the 18 to 24-minute range cited earlier should be read as closer to a floor than a ceiling. It accounts only for the mechanical minimum required for the act itself across 3 separate instances, not for anything before or after. Set against Patrick's 2 camera-verified sightings on opposite ends of that same window, the math doesn't get easier for an alternate perpetrator theory to survive. It gets harder, because the theory that has generated the most traction online isn't really about the 17 minutes at all. It's about whether Patrick was even the man on those security cameras in the first place. It started, as a lot of these do, with a single detailed message. A viewer sent it directly to the reporter who has covered this case since day one, laying it out point by point. Look at the shirt collar visible under the jacket in the CVS photo. It's light-colored. Look at the shirt visible in the restaurant photo. It reads as a darker blue. Look at the soles of his shoes, dark in one set of images, lighter in the other. Look at the hair, straight in the CVS footage, wavier by the time he's caught on camera at the restaurant. Individually, none of these are dramatic. A shirt collar, a shoe sole, a curl in someone's hair, each easily explainable on its own by something as mundane as a change of clothes between 2 stops or the angle of an overhead light. Together, stacked up by someone looking for a pattern, they start to feel like evidence of a switch, like maybe it wasn't Patrick at both stops. Maybe, the theory goes, it was Patrick and a friend trading places so that the real Patrick could have been somewhere else entirely during part of that window. It's worth taking a real moment with why a theory like this spreads the way it does, because the mechanism matters more than the specific claim. Nobody involved in that courtroom, not the prosecution, not the defense, not a single witness under oath, has ever disputed that it was Patrick Clancy on both sets of security footage. It has never once been raised as an issue inside the trial itself. That's not a small detail, and it's worth sitting with for a moment before moving on. Prosecutors in a case like this have every incentive in the world to find and use any legitimate doubt about a spouse's alibi. Defense attorneys have just as much incentive to raise reasonable doubt anywhere it might actually exist, and neither side benefits from leaving a real gap in an alibi unexamined if that gap could actually change the outcome of the case. Neither side has touched this. The far more mundane explanation, that a man changed out of work boots and a half-zip jacket into sneakers and a full jacket sometime in a 22-minute window that included stops at 2 separate businesses, and that static security camera stills at odd angles and low resolution can make identical hair look different depending on how someone's tilted their head, has simply never needed defending in court, because nobody with access to the actual footage, the actual timestamps, and the actual chain of custody has ever seriously entertained the alternative. A criminal defense attorney who has followed this case closely put it plainly when asked directly about the doppelganger theory. The consensus, full stop, is that it's Patrick in both places. Different shoes and a different jacket do not add up to a different man. They add up to someone who, over a 22-minute stretch that included 2 stops, was not photographed under laboratory lighting conditions and did not owe the internet a consistent outfit. There's a broader, more general pattern worth understanding here, separate from this specific case, because it explains why theories like this take root so easily in any high-profile trial. This next part is general context, not a claim about anyone involved in this specific case, but it's useful background for understanding what you're watching happen online in real time. Content built around "look what nobody's talking about" performs extremely well on social platforms because it offers viewers something a straightforward factual account can't. The feeling of being let in on something, of seeing what the professionals missed. Confirmation bias does the rest of the work. Once a viewer has decided a theory feels plausible, every subsequent detail, a shirt color, a shoe sole, a hesitant answer under cross-examination, gets read as further proof, rather than being weighed on its own. It's worth naming, as general psychological background, that confirmation bias rarely works alone. It tends to travel with a closely related pattern called motivated reasoning, where a person doesn't just notice evidence that supports a belief they already hold, but actively, if unconsciously, applies a much lighter standard of scrutiny to anything that confirms what they want to be true, while demanding a much higher standard of proof for anything that would require them to abandon it. In practice, that means a viewer already convinced Patrick was somehow involved will accept a blurry, low-resolution photo comparison as meaningful evidence, while dismissing sworn courtroom testimony, cross-examined under oath and subject to perjury laws, as somehow less trustworthy, even though by any objective measure of reliability, the reverse should almost always be true. This isn't a flaw unique to true crime audiences. It's a well-documented feature of ordinary human reasoning that researchers have studied across every domain from politics to personal relationships. It's simply worth naming directly here, because recognizing the pattern in yourself while watching a case like this is a genuinely useful, transferable skill, not something specific to Lindsay Clancy's trial. And because thousands of people can independently arrive at the same theory through the same viral post, it starts to feel validated by sheer numbers, even though every one of those thousands of people is looking at the same handful of screenshots, not independent evidence. None of this means every online theory about every case is wrong. It means the volume of people repeating a claim is not, on its own, evidence that the claim is true, and it's worth holding on to that distinction as we go through the rest of these. There's a mechanical piece of this worth understanding too, because it explains why a theory like this one can feel like it's everywhere within days of a single post. Recommendation algorithms on most major platforms are built to maximize time spent watching, not accuracy, and they learn extremely quickly which specific framing of a claim keeps a viewer on the video longer. A still image with a red circle around a shoe, a slowed-down clip with a dramatic zoom, a thumbnail with a question mark and a wide-eyed expression. Once a platform system identifies that a particular angle on a story is generating unusually high engagement, it doesn't just show that video to more people who searched for it, it actively pushes it toward people who never searched for anything related to the case at all, based on loose behavioral similarity to other viewers who watch similar content. That's a structurally different distribution mechanism than how information used to spread. A newspaper article about a case reached roughly the same size audience whether it was accurate or sensational, because it was distributed the same way either time. A viral true crime theory video doesn't work that way. The more dramatic, more conspiratorial framing of a claim will, on average, be shown to dramatically more people than a sober-sourced explanation of the same underlying facts, not because platforms are deliberately favoring misinformation, but because the engagement metrics that decide what spreads simply can't tell the difference between "this is true and important" and "this is exciting to watch," and historically, exciting wins that contest most of the time. It's worth adding one more piece of general media literacy here, because it applies just as much to a video like this one as it does to any theory-driven content you'll come across elsewhere. The fact that a claim comes with a specific, confident detail attached to it, a timestamp, a shirt color, a precise dollar figure, doesn't automatically mean it's been verified. Specificity feels like rigor, and it's easy to mistake the two, but a wrong claim stated with 3 decimal points of precision is still wrong. The actual test isn't how detailed a claim sounds. It's whether the detail traces back to something you could independently check yourself, a court transcript, a public exhibit, a named witness under oath, rather than another video's confident retelling of a claim nobody involved ever verified in the first place. There's a related trust dynamic worth naming too, sometimes described by researchers as a parasocial relationship, the one-sided sense of familiarity and trust a regular viewer develops toward a creator or commentator they watch repeatedly, even though that creator doesn't know them personally at all. That dynamic is powerful, and it's not inherently a bad thing. It's part of why people return to the same news anchors, the same podcast hosts, the same channels year after year. But it also means a viewer's trust in a specific claim can end up resting almost entirely on how much they like and relate to the person delivering it, rather than on the underlying sourcing behind the claim itself, which is exactly the vulnerability a theory-driven video is built to exploit, intentionally or not. The corrective isn't to distrust every commentator, including the one narrating this video. It's to hold the same basic question in mind regardless of who's talking. Does this claim point back to something checkable, or does it only point back to the person saying it, confidently, on camera? There's also a piece of testimony from this same stretch of the day that rarely makes it into the doppelganger discussion at all, and it's worth including because it cuts directly against the theory rather than just sitting beside it. On cross-examination, Patrick was asked directly whether he had his phone with him at both the CVS stop and the 3V stop, and he confirmed he did, because, as the prosecutor pointed out, he'd been seen using it on camera at both locations. That's a small detail with real weight. A phone has a location history, a carrier record, and in a case this heavily investigated, that kind of digital trail is exactly the sort of thing law enforcement checks quietly in the background well before a single theory about lookalikes ever reaches a TikTok comment section. If Patrick's phone had pinged a cell tower nowhere near either the CVS or the restaurant during the windows he was supposedly standing inside them, that is not the kind of discrepancy that stays buried. It becomes the actual heart of a very different criminal case, argued by a prosecution that has every reason in the world to use it if it existed. No such discrepancy has ever surfaced in this trial from either side. It's also worth understanding, again as general background, exactly how unreliable a still image pulled from a security camera actually is for the specific job people online are asking it to do, distinguishing one person from another by clothing texture and hair shape alone. Most retail and restaurant security systems are built to record a wide field of view at a low frame rate, prioritizing storage efficiency over image fidelity, because their actual purpose is establishing that something happened in a given place at a given time, not producing courtroom-grade forensic portraiture. A single freeze frame from that kind of footage compresses fine detail heavily, distorts color under mixed indoor lighting, and can make identical fabric read as two different shades depending on where an overhead light happens to be angled relative to the camera in that specific frame. Hair that looks straight in one still and wavy in another is very often the same head of hair photographed at two different angles, under two different light sources, at two different moments of a day when static and humidity alone can change how it sits. None of this is a defense of any specific conclusion about this case. It's simply the reason forensic experts, when identity actually is in dispute in a criminal trial, testify from high-resolution source footage, timestamps, and often biometric analysis, not from screenshots zoomed in on a phone. When neither side in an actual trial with full access to the real footage, not compressed re-uploads, has ever raised an identity question, that absence is itself meaningful information, even though it doesn't make for as compelling a screenshot comparison as the theory does. It's worth knowing too, as general background on how trials actually handle this exact kind of dispute when it's real, that forensic video analysis is an established discipline with its own certified experts, its own peer-reviewed methodology, and its own long history of being called into criminal trials specifically to resolve identity questions from surveillance footage, frame rate interpolation, lens distortion correction, gait analysis, even careful measurement of a subject's height, against known fixed points in a store's layout. When an identity dispute is real and material to a case, this is the tool prosecutors or defense attorneys reach for, because it's substantially more reliable than the human eye comparing two compressed screenshots side by side on a phone. No forensic video analyst has ever been called in this case to dispute that it's Patrick Clancy in either set of footage on either side. That's not proof of absence on its own. Plenty of true, minor facts never get formally litigated simply because nobody disputes them. But in a trial this closely watched, with a defense team that has shown itself more than willing to challenge weak points in the prosecution's case elsewhere, the total silence on this specific question, from the only people in the room with access to the source footage at full resolution, is telling. The second major theory swirling around this case is closer cousin to the first. Not that Patrick was somewhere else that night, but that he simply wasn't investigated the way he should have been afterward. That, as one commenter put it bluntly, he's not charged because his family is the police. Part of what fuels this theory is a genuinely well-worn piece of true crime shorthand. It's always the husband. As general background, that instinct isn't pulled from nowhere. In cases where one spouse is killed and there's a documented history of conflict in the relationship, the surviving spouse does statistically represent a disproportionate share of eventual suspects, which is exactly why investigators routinely look hard at a spouse early in any homicide investigation as a matter of standard practice, not personal suspicion. But that statistical pattern describes a different, much more common scenario than this one adult killing another adult, usually a partner, inside an existing pattern of documented conflict. It doesn't map cleanly onto a case where the person who died is a group of children, where the surviving spouse has a fully corroborated, camera-verified alibi for the relevant window, and where the person who admits to the killings is not the spouse being suspected but someone else entirely. Applying a rule of thumb built for one kind of case onto a case that doesn't structurally resemble it is a common way true crime instincts, even reasonable ones, end up pointing in the wrong direction. There's a related, more mundane piece of general background worth understanding here too. How police departments are actually held accountable when a real conflict of interest exists. Since the his family is the police theory implicitly assumes that if a genuine connection existed, nothing would stop it from being buried. In practice, Massachusetts and most states have multiple structural checks specifically built to prevent that. Internal affairs review processes within individual departments, state-level oversight boards with authority to investigate misconduct independent of the department involved, and in any case that proceeds to an actual prosecution, a separate district attorney's office that reviews the investigative file independently before deciding what charges, if any, to bring, meaning even if a single officer had some personal connection to a family involved in a case, that officer is not the one deciding whether charges are filed. Multiple layers of people outside that hypothetical relationship would need to either miss or actively participate in covering up a conflict for the family as the police theory to hold, in a case that has already drawn this much outside legal, media, and public scrutiny. That doesn't mean police corruption never happens, and it doesn't mean every oversight system works exactly as designed in every case. Real documented failures of exactly this kind exist elsewhere in the country. It does mean that the theory needs actual evidence of one of those specific checks failing here, not just the existence of the checks being theoretically capable of failing somewhere. It's a serious accusation to make about any law enforcement agency, and it deserves to be taken seriously rather than dismissed outright, because police departments protecting their own is not a hypothetical problem. It has happened, documented in real cases in real departments more than once. But taking an accusation seriously means actually checking it against what's known, not assuming it's true because it's emotionally satisfying. What we know from testimony given by the first officers on scene is this. Responding officers found Lindsay on the ground and Patrick standing over her. One officer testified that as he approached, Patrick had a cell phone visible in his left hand, down by his side, and that he appeared to be trying to communicate with Lindsay before he noticed the officer's flashlight and moved away toward the house. Patrick then passed directly by that same officer near a bulkhead entrance, walking fast, saying nothing, heading toward the deck. Minutes later, officers heard screaming from inside the house, made their way to the basement and found Patrick there. And that's the moment he looked up and screamed the 4 words this story opened with. He was, by every account given under oath, fully cooperative from that point forward. He turned over pill bottles that he said he'd found in the center console of his truck. He told investigators about additional pills found in a nightstand drawer in the master bedroom. He turned over Lindsay's Apple Watch. It's worth understanding as general background why a wearable device like that is actually a meaningful piece of evidence, rather than just a personal item logged for the sake of thoroughness. Modern fitness and health wearables continuously record heart rate, movement, and often sleep and activity data, all time-stamped down to the second, which means a device like an Apple Watch can function almost like an independent, automated witness to a timeline, capable of showing elevated heart rate, physical exertion, or periods of stillness corresponding to specific moments investigators are trying to reconstruct, entirely apart from anyone's memory or testimony. That's part of why handing one over voluntarily, without being asked twice, tends to be read by investigators as a cooperative act rather than a suspicious one. Someone trying to obscure a timeline has an obvious incentive to lose a device like that, not walk it directly to police. There is one detail here that has drawn real, legitimate scrutiny, and it's worth naming directly rather than glossing past it. Patrick testified that some of the pills he found were given not to the state police, but to his own attorney, Kevin Reddington, and when asked why he handled those particular pills differently than the others, he said he did not know. He never explained it, and it was never fully resolved on the stand. That is a genuinely strange inconsistency in an otherwise fully cooperative account, and it is fair for anyone watching this trial to sit with it and wonder about it. There is a mundane, non-conspiratorial explanation that fits the available facts just as well as a sinister one. A person in the immediate, disorienting aftermath of finding their children dead is not necessarily making careful, consistent decisions about which pieces of physical evidence go to which party, and handing something to your own attorney in that state can reflect panic and confusion just as easily as it can reflect calculation. It is a much smaller and much more explainable inconsistency, though then his family controls the investigation. No testimony, no exhibit, and no ruling from the bench in this case has surfaced any actual connection between the Clancy family and the officers or investigators assigned to it. What's actually documented is a man who, according to police themselves, has a confirmed, camera-verified alibi for the window during which his children were killed, who called the incident in himself, and who, aside from the one unexplained detail about the pills handed to his attorney, handed over everything else he found without being asked twice. It's also worth understanding as general background and not as commentary on this specific department, how criminal investigations actually work behind the scenes, because it explains a related frustration a lot of online commenters have voiced, the sense that the public isn't being told everything. This is normal and it isn't unique to this case. Investigators frequently cannot release full details of an active case while it's still working its way through the system, because doing so can compromise the integrity of the prosecution, tip off information that hasn't been formally entered into evidence yet, or violate rules about what can be discussed publicly before a jury has heard it. Journalists covering ongoing trials, even ones with significant access, often don't receive full exhibits, body camera footage, or interview recordings until well after a case has been fully adjudicated, meaning after a defendant has been convicted or acquitted, and in some instances not until after sentencing. That's not evasion. It's closer to standard procedure. It means that right now, while this trial is ongoing, there may well be additional information about the investigation that simply hasn't become public yet, not because anyone is hiding a cover-up, but because that's how the system is built to work until a verdict is reached. Now let's talk about the theory that has probably generated the most emotionally charged discourse of all three, because it's the one that goes directly at Lindsay herself, the idea that she was never really experiencing a psychotic break at all, that she was, to one degree or another, faking it. This theory tends to lean on a specific handful of facts, and they are real facts pulled from real testimony, not invented for the internet. Multiple witnesses called by the prosecution, doctors, nurses, providers who interacted with Lindsay in the period leading up to that night, testified that they did not observe outward signs of psychosis in her. One provider testified specifically that Lindsay's thinking in their assessment was linear, goal-oriented, and that she did not appear to be responding to internal stimuli, a phrase used in psychiatric evaluation to describe someone reacting to hallucinations only they can perceive, like following something with their eyes that isn't there, or answering a voice no one else can hear. It's worth knowing, as general clinical background, that this language comes from a standardized tool called the mental status exam, a structured evaluation nearly every psychiatric provider performs and documents at each patient encounter, covering categories like appearance, mood, thought process, thought content, and perception. It's designed to be repeatable and comparable across different providers and different visits, which is exactly why courts rely on it so heavily in cases like this. It gives a jury a documented, contemporaneous professional snapshot of a patient's presentation at a specific moment in time, rather than relying entirely on a witness's memory of how someone seemed months or years after the fact. The trade-off, and it's a real one, is that a mental status exam only captures a narrow window, typically the length of a single appointment, which is precisely the limitation the defense's own expert testimony leaned on. A documented snapshot showing linear, organized thinking at 2 p.m. on a given day says something true and real about that specific hour, but it doesn't on its own rule out a genuinely different presentation at a different hour, particularly for a condition already established to wax and wane in the way postpartum psychosis is understood to. Another provider asked directly and pointedly whether Lindsay displayed disorganized thinking, word salad, or any of the more visibly obvious markers of active psychosis, said no, not in that specific snapshot of time they observed her in. There's also the matter of what Lindsay reportedly said, and did in the immediate aftermath, in the hospital. When asked how she was feeling, she is said to have responded with a single word: horrified. And then, according to testimony, she wrote down a question of her own. Do I have an attorney? She also, in that same window, requested that her healthcare proxy, the legal designation for who's authorized to make medical decisions on your behalf if you can't, be changed from Patrick to her own parents. And her phone search history, read into the record by the prosecution, showed a string of searches in the period beforehand covering bipolar symptoms, psychosis, whether someone could be in diabetic ketoacidosis without elevated blood sugar, and detailed questions about several psychiatric medications, including trazodone and Ativan. It's worth flagging directly that this specific piece of evidence is genuinely double-edged in a way a lot of the online commentary doesn't sit with. A person researching the symptoms of a condition is, on its face, equally consistent with two very different explanations. Someone building a cover story in advance, or someone frightened by what's happening inside their own head, trying to put a name to it the same way anyone reaches for a search bar when something feels wrong and they don't yet have the words for it. Both readings use the exact same search history as their evidence. Neither one is provable from the searches alone, which is exactly why this detail, like so much else in this trial, gets argued over by attorneys rather than settled by it. It's worth adding one more piece of general forensic background here, on why medical examiner testimony in particular tends to carry the weight it does in a trial like this. Medical examiners are structurally independent from both the prosecution and the police department that investigated the case. In Massachusetts, the Office of the Chief Medical Examiner operates as its own separate state agency, not as a division of the district attorney's office or the police, specifically so that a cause of death determination isn't being made by an office with a stake in how a case gets charged. That independence is part of why medical examiner testimony tends to function almost as neutral, load-bearing infrastructure for a trial like this one. Both sides typically build their competing theories on top of the same underlying medical findings, rather than disputing the findings themselves, because there's no obvious institutional incentive for a medical examiner's office to shade a finding toward either side. That's exactly the role the time of death window and the strangulation duration testimony have played in the timeline discussion earlier in this video. Neither side has meaningfully disputed those specific findings, only what conclusions should be drawn from setting them against Patrick's separately verified movements that evening. It's worth pausing on one of those specific search terms, whether someone can be in diabetic ketoacidosis without elevated blood sugar, because on its face it's an unusual thing to search for and it doesn't obviously connect to postpartum psychosis at all. As general medical background, diabetic ketoacidosis, usually shortened to DKA, is a serious, potentially life-threatening complication most commonly associated with type 1 diabetes, in which a dangerous buildup of blood acids called ketones develops, typically alongside very high blood sugar, which is exactly why a search asking whether it's possible without elevated blood sugar reads medically as a slightly unusual and specific question, the kind of thing more likely to come from either a person with a personal or family connection to diabetes, or someone in a state of racing, anxious, non-linear late-night searching, jumping between loosely related health worries rather than following one coherent train of thought. Neither side in this trial has offered a fully conclusive explanation for that specific search, and it's a good example of exactly the kind of detail that looks meaningful in isolation but doesn't resolve cleanly in either direction. A reminder that not every piece of evidence in a trial this document-heavy points decisively one way, and that a jury's job includes sitting with real, permanent ambiguity on individual details while still reaching an overall verdict on the larger question in front of them. There's also a more general, practical piece of context worth having about how a search history like this even makes it into a courtroom in the first place. Digital evidence pulled from a phone, browser history, app usage timestamps, has to go through a formal forensic extraction and authentication process before it can be presented to a jury, typically performed by a trained digital forensics examiner using specialized software that creates a verified, unaltered copy of a device's data, along with a documented chain of custody establishing exactly who handled the device and when, from the moment it was seized through the moment it's shown in court. That process exists specifically to prevent the kind of argument that comes up constantly in online true crime discourse, that a screenshot could have been faked, edited, or taken out of context, because a properly authenticated forensic extraction is accompanied by metadata. A defense attorney can independently examine and challenge if anything about it looks altered. Neither side in this trial has challenged the authenticity of the search history data itself. What's being argued about is only what it means, not whether it's real. It's worth connecting this back briefly to the pill bottles and the Apple Watch discussed earlier in this video, because they all sit under the same general evidentiary umbrella: physical and digital items that had to be collected, logged, and preserved in a way that could later withstand scrutiny in open court. As general background, every item of physical evidence in a criminal case, a pill bottle, a phone, a piece of clothing, is supposed to be tracked through a documented chain of custody from the moment it's collected: who took possession of it, when, how it was stored, and who had access to it at every stage between collection and the courtroom. Any real gap in that chain becomes an opening a defense attorney can use to argue the evidence shouldn't be trusted, or shouldn't be admitted at all. The fact that Patrick's turned over pill bottles, the nightstand pills, Lindsay's Apple Watch, and her phone search history have all made it into this trial as accepted, unchallenged exhibits, rather than being excluded or fought over on procedural chain of custody grounds, tells you that whatever legitimate disagreements exist about what this evidence means, nobody involved in this case has found a real, documented problem with how it was collected and handled in the first place. The other medications named in that search history, trazodone, Ativan, and Prozac, are each worth a brief, general note, because true crime discussion of a search history like this sometimes treats any medication search as inherently suspicious, when in reality these are three of the most commonly prescribed psychiatric medications in the country. Trazodone is most frequently prescribed off-label for sleep, alongside its original use as an antidepressant. Ativan, the brand name for lorazepam, is a fast-acting anti-anxiety medication in the benzodiazepine class, one that does carry a real, well-documented risk of physical dependence with regular use, which is exactly the kind of thing a patient who's been prescribed it, or is considering asking a doctor about it, might reasonably want to research on their own. Prozac, the brand name for fluoxetine, is one of the most widely prescribed antidepressants in the world and has been for decades. Searching detailed questions about any of these medications is, on its own, closer to ordinary patient behavior than to anything resembling premeditation. Millions of people research their own prescriptions, side effects, and interactions every year, particularly anyone actively working with a provider to find the right medication and dosage during a difficult psychiatric period, which the broader record in this case shows Lindsay was already doing in the months before the killings. Stack all of that up, and you can understand why it reads to some like the record of someone who was thinking clearly enough to research symptoms, clearly enough to ask for a lawyer within what may have been hours of a psychotic episode supposedly ending, clearly enough to make a calculated legal move about who controls her medical decisions. But that reading only works if you leave out the testimony that runs directly against it, and there was a substantial amount of it. A defense witness, a doctor who evaluated Lindsay's psychiatric history in the months leading up to the killings, testified about a voluntary psychiatric commitment Lindsay had checked herself into, in a locked ward months before the deaths, out of documented fear that she might hurt herself or her children. That same witness described what Lindsay had reported experiencing, what the witness called ideas of reference, a specific, recognized psychiatric symptom in which a person becomes convinced that other people can perceive their private thoughts, that strangers or authority figures can somehow read what's happening inside their head. In Lindsay's case, this reportedly manifested as a fear that her children's school teachers could hear her thoughts and would use that against her to take her children away. As general clinical background, ideas of reference sit on a spectrum with a closely related but more severe symptom called delusions of reference, where the belief hardens into a fixed, unshakable conviction rather than a fear the person can still recognize, at least partially, as possibly irrational. A person might become convinced a television broadcast is speaking directly to them, or that strangers on the street are exchanging meaningful glances specifically about them. Clinicians distinguish this from ordinary self-consciousness or social anxiety by its intensity and its resistance to reassurance. A person experiencing genuine ideas or delusions of reference typically cannot be talked out of the belief with logic or evidence, because the belief isn't operating on the same evidentiary rules ordinary reasoning does. It's a direct product of the underlying psychiatric disturbance, not a conclusion reached through faulty but ordinary logic. Understanding that distinction is part of what expert witnesses in cases like this one are actually trained and retained to evaluate. Not just whether a defendant said something that sounds unusual, but whether the specific structure and intensity of that belief matches a recognized clinical pattern. The same doctor explains something that matters enormously to how you should read every piece of the "she showed no signs" evidence. Psychotic symptoms in real clinical presentations are frequently intermittent rather than constant. A person can experience active auditory hallucinations on one day, and present as completely lucid, linear, and goal-directed the next, sometimes even within the same day. The doctor used a specific phrase for this, one that's actually a recognized clinical term. Symptoms waxing and waning, like waves coming in and going back out. And critically, this same defense witness testified that even someone in the middle of active psychosis retains the physical and cognitive capacity to do ordinary things. Make a phone call, drive a car, hold a simple conversation, because psychosis does not typically strip away basic motor function or verbal ability. It distorts perception and judgment, which is a very different thing than losing the ability to function at all. That distinction matters enormously for how you interpret Lindsay asking a coherent question in a hospital bed, or driving to an appointment, or sending a lucid text message days earlier. None of those things, according to actual clinical testimony given under oath, rule out active psychosis. They just don't look like what most people going in expect psychosis to look like. It's worth taking a real detour here into general information about postpartum psychosis, because it is one of the most misunderstood conditions discussed in true crime, and because understanding the general clinical picture, separate entirely from any conclusion about this specific case, which is still being decided by an actual jury, helps make sense of why the testimony on both sides can sound so contradictory. Postpartum psychosis is rare, far rarer than postpartum depression, generally estimated in medical literature to occur in somewhere around 1 to 2 out of every 1,000 births. It is also considered a genuine psychiatric emergency, distinct from the more commonly discussed and more common postpartum depression, because it can develop rapidly, sometimes within days of delivery, sometimes not until weeks or months later, and because its symptoms can include a break from reality itself, delusions, hallucinations, severe confusion, and in a small but devastating subset of cases, thoughts of harming their baby or other children in the home, sometimes tied to delusional beliefs that harm is somehow protective, or that the world is too dangerous a place for the child to remain in. This is general clinical background, not a diagnosis of anyone discussed in this video, and it is not offered here as an excuse for any harm caused, but it is offered because the condition itself is so poorly understood publicly that jurors, viewers, and commenters alike often default to imagining it as something closer to what's portrayed in movies. Constant, obvious, theatrical. Real psychiatric literature describes something messier and less visually dramatic, which is exactly the gap this particular trial's competing witnesses seem to be arguing over. Doctors who saw Lindsay during calmer windows describing linear thinking, and a doctor working from her documented history describing a condition that, by its own clinical definition, doesn't stay visible all the time. It's worth being specific as general clinical background about what a command hallucination actually is, since it's the exact term used by the defense's own final expert witness in this case. A command hallucination is a specific subtype of auditory hallucination in which a person perceives a voice, one that feels to them as real and external as any other sound in the room, instructing them to take a specific action, sometimes something mundane and sometimes something severe and dangerous. Clinicians who study this symptom generally note two things that matter for understanding testimony like this. First, command hallucinations are considered one of the more clinically serious symptoms within the broader category of psychosis, precisely because they carry a direct, and sometimes very difficult to resist, behavioral instruction attached to them, rather than simply distorting a person's perception of their surroundings. And second, research on this symptom has found that whether a person acts on a command hallucination depends on a range of factors, including how consistent the commanded action is with other delusional beliefs the person is experiencing at the same time, and how much insight the person retains in that specific moment into whether the voice is real. That's the clinical backdrop a jury is being asked to weigh against Dr. Mack's competing assessment that Lindsay was experiencing major depressive disorder rather than active psychosis, two different diagnostic pictures that would predict two very different explanations for the same set of actions. It's worth being precise as general clinical background about how major depressive disorder and psychosis actually differ, since Dr. Mack's rebuttal testimony rests specifically on that distinction. Major depressive disorder in standard clinical classification is defined primarily by persistent low mood, loss of interest or pleasure in previously enjoyed activities, changes in sleep and appetite, fatigue, and in more severe presentations thoughts of death or self-harm. But critically, a diagnosis of major depressive disorder, even a severe one, does not by itself involve a break from reality. A person can be profoundly, dangerously depressed while still accurately perceiving what is real and understanding the consequences of their actions. Psychosis is a categorically different clinical phenomenon, a disturbance in a person's basic contact with reality itself, through hallucinations, delusions, or severely disorganized thinking. It's possible and clinically recognized for the two to occur together, what's sometimes called depression with psychotic features, but they are not simply 2 points on the same severity scale, where depression eventually just becomes psychosis if it gets bad enough. That's precisely the clinical line Dr. Mack's testimony draws. His assessment places Lindsay's presentation on the depression side of that line, severe but reality intact, while Dr. Resnick's assessment places her on the psychosis side of it, with an active break from reality driving the killings themselves. It's a genuinely technical, high-stakes clinical distinction for a jury with no medical training to be asked to adjudicate, which is exactly why so much of this trial's final stretch has centered on 2 doctors, not 2 eyewitnesses, disagreeing with each other under oath. This general condition has come up in American courtrooms before this one, and it's worth naming the most widely known comparable case, purely as public background, not as a stand-in for anything specific about Lindsay Clancy's own diagnosis or state of mind. In 2001, Andrea Yates, a Texas mother, drowned her 5 children during a documented psychotic episode. She was initially convicted of murder. That conviction was later overturned on appeal due to a factual error in expert testimony, and at retrial she was found not guilty by reason of insanity and committed to a state mental hospital rather than prison, where she has remained under psychiatric care in the years since. That case, like this one, generated enormous public disagreement at the time about whether a mother who had, by her own admission, killed her children, could ever legitimately be found not criminally responsible for it. And it's part of why the legal standard for an insanity defense exists in the specific, narrow form it does today, not as a loophole but as a genuine acknowledgement built into the law itself, that severe psychiatric illness can, in rare and clinically documented circumstances, remove a person's actual capacity to understand what they're doing. Public comfort with that legal reality has never been universal, then or now, and it's worth sitting with the discomfort rather than resolving it too quickly in either direction, because the discomfort itself is part of what makes cases like this one so hard to look away from. There's also a broader research picture worth knowing, again as general background rather than commentary on any individual defendant. Researchers who study filicide, the killing of a child by a parent, have found across multiple studies that a meaningful subset of cases involving mothers specifically are connected to documented, diagnosable postpartum psychiatric illness rather than to abuse, neglect, or premeditated malice in the way those terms are usually understood. That doesn't mean every case involving a mother and a dead child fits that pattern. Plenty do not, and courts treat each one individually for exactly that reason. It means the pattern is real and recurring enough that clinicians, researchers, and courts have all had to build a vocabulary and a legal framework specifically around it, rather than treating every instance as either straightforward premeditated murder or an isolated, inexplicable anomaly, a vocabulary that exists precisely because these cases, however rare, have recurred often enough across decades and jurisdictions to demand a real studied response rather than being treated as one-off horrors with nothing to learn from them. Understanding that this is a documented, recurring clinical and legal category, not a novel defense strategy invented for this case, is useful context for weighing how seriously the insanity defense is being treated inside that Plymouth County courtroom, separate from how it's being treated in the comment section underneath the video about it. It's also worth knowing, purely as general public health background, that cases like Andrea Yates's and more recently high-profile coverage of cases like this one have had a documented ripple effect on hospital policy more broadly. In the years following several widely publicized maternal mental health tragedies, professional medical organizations in the United States significantly expanded formal guidance around routine postpartum depression and psychosis screening, recommending that obstetric providers screen new mothers using standardized questionnaires not just once, but at multiple points across pregnancy and the months after delivery, specifically because symptoms can emerge or intensify well after a patient has already been discharged from a hospital's direct care and handed off to primary care or pediatric visits, where the focus naturally shifts to the baby rather than the parent. Many hospital systems around the country have, over the past decade, adopted more structured handoff protocols for exactly this reason, building in mental health check-ins at newborn pediatric visits, not just the mother's own follow-up appointments, precisely because those follow-up windows are so easy for an overwhelmed new parent to skip or minimize. It's also worth naming the general clinical risk factors research has associated with postpartum psychosis, again purely as background rather than as commentary on this specific case. The strongest documented risk factor by a significant margin is a personal or family history of bipolar disorder. Postpartum psychosis is now understood by many researchers as sitting closely related to bipolar spectrum illness rather than functioning as a fully separate condition, which is part of why a family history of bipolar disorder, even one that was never diagnosed or treated as such, can meaningfully raise risk. Other documented factors include a prior episode of postpartum psychosis in an earlier pregnancy, severe sleep deprivation in the days immediately surrounding delivery, and for some patients, a first pregnancy specifically, since first-time parents typically experience the steepest and most disorienting adjustment to a newborn's unpredictable sleep demands. None of that is a checklist for diagnosing anyone after the fact, and it isn't offered as one here. A jury weighing an insanity defense is working from actual clinical evaluation and documented history, not a generic risk factor list. It's included because it's useful, responsible general information for anyone watching this who is currently pregnant, has recently given birth, or has a partner or family member in that window. Postpartum psychosis is a real, recognized psychiatric emergency. It is treatable with fast intervention, and every major medical association that studies it stresses the same thing. Any sudden, frightening change in thinking, perception, or mood in the weeks or months after childbirth warrants immediate medical attention, not private embarrassment or a wait-and-see approach, precisely because the condition can escalate as quickly as it can. None of this is a claim about what any specific medical provider did or didn't do in Lindsay Clancy's own care. That question is the actual subject of Patrick's pending civil lawsuit, and it will be litigated on its own separate timeline, with its own separate evidentiary record, regardless of what the criminal jury ultimately decides. It's simply useful background for understanding why a case like this one tends to generate conversation among medical professionals as well as true crime audiences, because whatever the jury eventually concludes about Lindsay's own individual culpability, the broader clinical questions about how well the healthcare system screens for and catches this specific rare and dangerous condition remain alive and evolving concern independent of any one case's outcome. There's also real testimony that complicates the "she faked it entirely" theory from a source you might not expect. Patrick himself, on the stand, called as a witness for the prosecution, Patrick testified that in the weeks before the killings, Lindsay had described having what she called intrusive thoughts to him directly, thoughts of harming the children. When asked what those thoughts specifically involved, he said she'd described thoughts of hurting the kids, or of them having some kind of serious medical ailment. He gave a specific example that she'd become disproportionately worried a stomachache their daughter had was actually a liver problem, far beyond what the situation called for, a level of alarm out of proportion to the actual medical facts in front of her. Prosecutors, notably, pushed to draw a distinction in this same testimony, asking Patrick whether Lindsay had described these as intrusive thoughts of her own, versus an external voice commanding her to act, and Patrick confirmed she'd described them as her own thoughts, not an outside voice, at least in that one specific conversation he could recall clearly enough to testify to. That distinction matters legally, and we'll come back to exactly why in a moment. But the underlying fact remains. The one witness in this trial with arguably the most day-to-day, unfiltered access to Lindsay's actual mental state in the weeks leading up to that night, her own husband, called by the prosecution, not the defense, testified under oath that she had told him directly she was having disturbing, unwanted thoughts about harming their children. That is not a small thing, and it is not nothing. Whatever conclusion you personally draw about what was happening inside Lindsay Clancy's mind that January evening, it is worth remembering that the "she was fine" this was all performance theory has to somehow explain away her own husband's sworn testimony that she wasn't fine, and had told him so herself in her own words weeks before any of this happened. Then there are the journal entries, which have become almost a text of their own in this case, read and reread by commentators looking for evidence in either direction, sometimes treated as a confession of premeditation, sometimes treated as proof of a mother in genuine crisis reaching for help that never fully arrived. One entry, read into the record, described being obsessed with his sleep and nap schedule like to the minute, and went on. Hearing him cry for 1+ hours and not intervening just about killed me. I even said the words "I want to die" to Pat, while he was crying. Another entry, from what appears to have been a notes app on her phone, is longer and more openly conflicted, describing sadness at not feeling able to parent her third child the way she had her first, describing a sense of resentment toward her other children for taking attention away from her baby son, Callan, and immediately noting that this wasn't fair to them, describing being on the fence about starting medication for anxiety and depression, and in the same entry describing wanting nothing more than an ordinary peaceful evening, getting the kids to bed, relaxing with her husband, falling into a deep sleep, and getting up the next day to do it all again. Read one way, these entries are the private record of severe postpartum depression tipping toward something far more dangerous. A mother documenting her own unraveling in real time, reaching for language to describe something she didn't yet have a real name for. Read the other way, by people convinced this was all staged. They're treated as a paper trail being laid down in advance, evidence built for a defense that hadn't been filed yet. It's worth noting how much interpretive work is actually being done by the reader in either case, rather than by the text itself. The words on the page describe exhaustion, ambivalence, love, and dread in roughly equal measure, and neither reading fully accounts for all four of those things being present at once, in the same entry, written by the same person, on what was almost certainly one of many ordinary, difficult nights that simply happened to survive as a document because of what came after it. The honest answer, and the one every attorney involved in this case would likely agree with even while disagreeing about what it means, is that nobody outside Lindsay Clancy's own mind can know with real final certainty which of those two competing readings is actually true. What can be said is that the entries exist, they were entered as real evidence, they were written well before anyone, including Lindsay herself, had any real reason to be constructing a legal defense out of ordinary private words, and they describe in her own handwriting in her own words, a woman who was struggling, whatever ultimately caused that struggle to end the way it did. It's worth being honest, too, about how differently these entries tend to land depending on who's reading them and when. A parent reading this at 2 a.m. during their own hard stretch with a newborn is going to recognize something in these words that a reader with no children, or a reader decades removed from that specific kind of exhaustion, simply won't feel the same way, not because one reading is more correct than the other, but because trauma and exhaustion of this specific kind are genuinely difficult to access secondhand. That's part of why these entries have generated such split reactions online. Two people can read the exact same paragraph in good faith, and walk away with completely different instincts about what it reveals, purely because they're bringing different lived experience to the same page. If you've ever parented a newborn while also trying to keep two older, smaller kids fed, dressed, and reasonably happy, some of what's in those entries will land differently than it does for someone reading them cold. The exhaustion of a child crying for over an hour and not being able to fix it. The guilt of feeling like your attention is being split in a way that shortchanges everyone, including the baby you're supposedly prioritizing. The specific quiet dread of realizing you said something out loud, "I want to die," that you didn't fully mean in the moment but that came out anyway, because you were that tired and that overwhelmed and there was nobody else in the room to hear it land. Almost every parent who has been through a genuinely hard stretch with young children has some version of that feeling somewhere in their history, even if it never got written down, and even if it never came anywhere close to what happened in that house. That's not the same as saying what Lindsay Clancy did was understandable, or that ordinary parental exhaustion explains it. It doesn't, and nothing in this video is intended to blur that line. The overwhelming majority of parents who have ever said something like, "I want to die" out loud in a moment of pure exhaustion, never come anywhere close to acting on it in any form, let alone the way this case ended, which is exactly why postpartum psychosis and severe postpartum depression are understood clinically as distinct from ordinary new parent exhaustion, however much their early language can overlap on the page. It's saying that the entries read the way they do to so many people who followed this case, precisely because they describe a feeling a lot of parents recognize in miniature, stretched out to a length and an intensity that, for most people, thankfully never arrives. We're a good way into this now, and it feels like the right point to step back for a second because this is genuinely difficult material, and it's worth naming that plainly rather than rushing past it. If you've lost someone, if you've struggled with your own mental health after having a child, or if you simply find this kind of case hard to shake once you've started reading about it, that reaction is normal, not a sign you're too sensitive for this kind of story. Almost everyone who has followed this trial closely describes some version of the same thing. An inability to look away, paired with a real discomfort about why they can't. Part of what keeps people locked into a case like this is the desire to solve it, To land finally on a clean explanation that makes sense of something senseless. That instinct is human and it isn't shameful. It's also, as we've seen already and will see again, exactly the instinct that theories like the doppelganger footage and the corrupt investigation claim are built to exploit, because a clean villain is always more comforting than a genuinely tragic, genuinely complicated collapse with no single person to blame for all of it. This is also, honestly, why a case like this belongs in a longer format rather than a 60-second clip, and it's part of why we build these episodes the way we do. A shortcut can show you the CVS timestamp or the shirt collar in isolation out of order with no room for the testimony that actually explains it, and it will always feel more damning that way than it does once you've sat with the full context. That's not a knock on anyone who's encountered this case only in fragments. Most people have, because fragments are what the platforms hand you by default. It's the reason this channel keeps going back to primary testimony instead of recap footage, and it's the reason a case this layered gets the full walkthrough treatment instead of a highlight reel. If that's the kind of coverage you'd rather have in your feed than the fragments, subscribing is what keeps this channel able to keep doing it this way, case after case, instead of chasing whatever angle happens to be trending that week. We're not going anywhere on this one either. There's still real ground to cover, so let's keep going. Let's move to the fourth theory, the one that's arguably the strangest of the bunch because it doesn't involve Lindsay or Patrick at all. It involves a man named Michael Phippen. Phippen is the current owner of the house at 47 Summer Street in Duxbury, the former Clancy family home. According to public records and his own professional history, Phippen worked as an assistant district attorney for Plymouth County, the same office now prosecuting Lindsay Clancy, for a period between April of 2016 and December of 2018. He now oversees a criminal defense department at a private firm and maintains his own criminal defense practice. He purchased the Clancy home in January of 2024, roughly a year after the killings, for $675,000. Once this connection surfaced online, reportedly first via a TikTok video sent directly to a reporter with the caption, "Did you see this?" It snowballed into a theory that Phippen was somehow conspiring with Patrick and his former colleagues at the DA's office to ensure Lindsay, rather than Patrick, was the one criminally charged. Set against actual facts, this theory falls apart almost immediately, and it's worth walking through exactly why, because the chronology alone does most of the work. Phippen began working at the Plymouth County DA's office in April of 2016, years before Lindsay and Patrick Clancy were even married. He left that job in December of 2018, more than 4 years before their children were killed. He purchased their former home more than a year after the killings occurred, well after the murder charges against Lindsay had already been filed, at a price that reasonably reflects a documented and disclosed history of violent deaths in the property, a fact any home seller is legally required to make known to a buyer. There is no timeline overlap here connecting Phippen to this case in any operational sense, no period where he worked for the office prosecuting Lindsay Clancy while that prosecution was happening, no financial or professional relationship documented anywhere between him and either the DA's office or the Clancy family beyond a straightforward real estate transaction that took place well after the fact. What is documented is a single legal dispute involving Phippen, and it's genuinely interesting in its own right, separate from the conspiracy theory it got folded into. Prosecutors requested what's called a jury view of the home, a formal in-person visit where jurors are physically brought to a relevant location so they can observe distances, sightlines, and spatial layout for themselves, something photographs and floor plans can't fully substitute for. Phippen, through his attorney, opposed the request. His attorney argued in a pretrial hearing that Phippen had already been fully cooperative, giving prosecutors unlimited access to photograph and measure the property in advance, and that a formal jury view would be genuinely disruptive. A bus full of jurors, a likely police presence given the profile of the case, neighbors, a domestic partner who works from home, pets, all converted for a day into the backdrop of one of the state's most publicized trials. The prosecutor, arguing for the view to move forward, pushed back sharply and personally, noting that Phippen was himself a former prosecutor from that same office, that he understood exactly how cases like this were built and why an in-person understanding of the space, how long it actually takes to move from the basement where the children were killed to the bedroom Lindsay went to afterward, how high that second-story window actually sits above the ground, mattered in ways photographs alone couldn't convey. Phippen's attorney's argument, in his own words from that pretrial hearing, is worth including more fully, because it's a more sympathetic, more human position than he's hiding something. once you actually read it rather than a summary of it. He described his client as someone who had already gone well out of his way to be accommodating, giving the Commonwealth unlimited time and access to photograph and measure the property in advance, and who was simply trying to avoid what he called, without quite wanting to use the word, something close to a circus, a bus of jurors, a likely state police presence given the profile of the case, neighbors watching, a domestic partner who works from home, and would have to clear out of her own house for a day, pets that would need to be managed, all for a proceeding whose exact date and duration weren't even fully settled yet. That's a genuinely reasonable, ordinary set of concerns for anyone facing the prospect of a jury bus parking outside their front door, the kind of disruption most homeowners, regardless of their own professional background, would have real reservations about. The prosecutor's response, equally worth hearing in full rather than compressed, that's seeing the space in person, how long it actually takes to move from the basement where the children were killed up to the bedroom Lindsay went to afterward, how low that second-story window actually sits when you're standing beneath it rather than looking at a photograph of it, was something jurors were entitled to experience directly, and that Phippin's own background as a former prosecutor in that very office made his resistance to it, in her view, particularly hard to square with genuine privacy concerns rather than something else. The judge, weighing both of those legitimate positions, sided with the prosecution. The jury view took place on July 31st. That entire exchange, a legitimate legal dispute between two officers of the court arguing about jurors visiting a crime scene, is the actual, sourced version of events that got compressed online into the Duxbury, bought the murder house to help cover it up. It's a reminder of something that's true across a lot of these theories. The true, boring, procedurally correct version of events is almost always available in the public record. It just requires reading the transcript instead of the caption. It's worth pausing here for some general context on what a jury view actually is and why courts use them, because it's a genuinely unusual procedure that a lot of viewers have probably never encountered before this case. This is general legal background, not specific commentary on this trial. A jury view is not a chance for jurors to conduct their own investigation, gather new evidence, or form opinions outside what's presented in court. It's tightly controlled by the judge, typically escorted, with strict limits on what jurors can do, touch, or discuss while there. Courts authorize them relatively rarely, and mostly in cases where spatial relationships genuinely matter to the facts at issue, where a jury's understanding of a case would meaningfully improve from physically standing somewhere rather than only seeing a photograph or a diagram of it. The fact that it was requested and ultimately granted in this case reflects how central the physical geography of that house, the distance from basement to bedroom, the height of that upstairs window, has become to how the jury will eventually have to weigh what they've heard. Let's talk now about the legal mechanism at the actual center of this trial, because it's the piece almost none of the online theorizing actually engages with, even though it's the only question the jury is legally required to answer. This is general legal background on how the insanity defense works, not a specific claim about how it will apply here. That's for the jury, not for us to decide. In Massachusetts, as in most states, a defendant can be found not guilty by reason of a lack of criminal responsibility if a mental disease or defect substantially impaired their ability, at the time of the offense, to appreciate the wrongfulness of their conduct or to conform their conduct to the requirements of the law. It is not a claim that the act didn't happen. It is not a claim that the person is somehow not to blame in a moral sense. It's a narrower, more technical legal standard about a defendant's actual mental state, in the specific moment the crime occurred. There's a legal Latin term for the underlying concept that's worth understanding because it comes up constantly in cases like this. Mens rea, meaning guilty mind. Most serious crimes require prosecutors to prove not just that a defendant committed a physical act, but that they did so with a certain guilty state of mind, intent, knowledge, recklessness. An insanity or not criminally responsible defense argues that a severe mental illness effectively erased the defendant's capacity to form that guilty mind in the way the law requires, even while the physical act itself is fully conceded. It's worth knowing that this admission isn't just something Lindsay's defense has said out loud in the courtroom during this trial. Well before trial began, her attorneys formally attempted to file a written admission acknowledging her role in the children's deaths specifically so that the entire trial could be narrowed down to a single question: her mental state at the time. The idea procedurally was to remove any dispute over the physical facts of what happened and let the jury focus exclusively on the psychiatric evidence. Prosecutors opposed that move, arguing that splitting the case into separate phases that way wouldn't actually simplify anything, since the underlying evidence in each phase would end up being nearly identical anyway, and the trial ultimately proceeded as one combined proceeding rather than a bifurcated one. It's a small procedural fight in the grand scheme of the case, but it tells you something worth knowing. The defense has been trying since well before opening statements to keep this jury's attention locked as tightly as possible on the mental state question, because that question is the only one where they believe they have real ground to stand on. This is why Lindsay Clancy's defense team can, and has, openly admitted she killed her children, while simultaneously arguing she should not be found criminally guilty of murder. Those two positions aren't actually in tension with each other under the law, even though they can feel deeply counterintuitive to someone encountering this kind of defense for the first time. It's also why the jury in this case, per court proceedings, has been instructed on a lesser-included offense of second-degree murder in addition to the primary charges and the insanity defense, meaning jurors ultimately have essentially two live paths to weigh, not a simple binary of guilty or not guilty. There's one more piece of general legal background worth having before we move on, because it's specific to Massachusetts and it matters for how the prosecution has had to build its case. Unlike many states where first-degree murder generally requires proof of premeditation alone, Massachusetts law recognizes three separate, independent theories under which a killing can qualify as first-degree murder: deliberate premeditation, extreme atrocity or cruelty, and felony murder, and a prosecution only needs to prove one of the three to a jury's satisfaction, not all of them. Deliberate premeditation is roughly what it sounds like: a decision to kill formed with actual reflection beforehand, even if that reflection only takes place over a matter of minutes rather than days. Extreme atrocity or cruelty is a separate, distinct theory that doesn't require any showing of advanced planning at all. It asks instead whether the manner of the killing itself was disproportionately violent, prolonged, or cruel relative to what would have been necessary to cause death, weighed against a specific set of factors judges instruct juries to consider, including the method used and how much suffering it involved. This matters directly to this case because it means the prosecution doesn't have to convince the jury Lindsay Clancy sat down and planned this killing days in advance to secure a first-degree murder conviction. A jury could, in theory, reject the idea of premeditation entirely and still convict on a first-degree theory if they found the manner of the deaths met the extreme atrocity or cruelty standard instead. That's a meaningfully different and more layered legal fight than most viewers following a case like this from the headlines alone would assume it to be. As further general background, Massachusetts case law over the decades has developed a specific, non-exhaustive list of factors judges instruct juries to weigh when considering whether a killing meets the extreme atrocity or cruelty standard. Among them, whether the defendant was indifferent to or took pleasure in the victim's suffering, the consciousness and degree of the victim's suffering, the extent of the injuries inflicted, the number of blows or the duration of the act, the manner and means of inflicting death, and the disproportion between the means needed to cause death and the means actually used. A jury doesn't need to find every one of those factors present. Established case law holds that even a single factor, if serious enough on its own, can support a finding of extreme atrocity or cruelty. It's a genuinely difficult, clinical-sounding list to read next to a case involving 3 young children, and it's included here not for shock value but because it's the actual legal language this jury has been instructed to apply if they get to that question at all. A reminder that even setting aside the entire insanity defense question, the first-degree versus second-degree question alone requires the jury to make a series of specific, granular factual findings, not a single gut-level judgment about how bad the crime feels in the abstract. 2 more pieces of general legal background are worth having before we go further, because they change how you should read everything else in this trial. First, on who actually has to prove what, and on what beyond a reasonable doubt actually means, since it's a phrase used constantly in trial coverage without always being explained. As general legal background, beyond a reasonable doubt is the highest standard of proof used anywhere in the American legal system, deliberately set higher than the standards used in civil cases like Patrick's pending lawsuit, which typically only require a preponderance of the evidence. Essentially, that something is more likely true than not. Reasonable doubt doesn't mean absolute mathematical certainty. Courts generally instruct jurors that it means a doubt based on reason and common sense arising from the evidence, or the lack of it, not a doubt manufactured out of pure imagination or an unwillingness to decide. It's an intentionally demanding standard, built on the principle that it's better to risk letting a guilty person go free than to risk convicting an innocent one, which is exactly why the burden-shifting rule matters as much as it does here. In Massachusetts, as in a majority of states, once a defendant raises a genuine insanity defense, the burden shifts to the prosecution to prove, beyond that same demanding reasonable doubt standard, that the defendant was in fact criminally responsible. Meaning it is the Commonwealth's job to convince the jury Lindsay Clancy was capable of understanding right from wrong that evening, not the defense's job to prove she wasn't. That's a meaningfully different posture than most criminal trials, where the defense typically only needs to create reasonable doubt about an element the prosecution already carries the full burden on. Second, on what a second-degree murder finding would actually mean if the jury doesn't accept the insanity defense but also isn't convinced the killings meet the higher legal threshold for first-degree murder. In Massachusetts, second-degree murder still carries a mandatory life sentence, but with eventual parole eligibility, generally after 15 years, versus first-degree murder's life sentence without the possibility of parole. That's why the lesser-included charge matters practically, not just technically. It's the difference between three legally distinct outcomes, not two, sitting in front of that jury. Not criminally responsible and committed to psychiatric care rather than prison, guilty of second-degree murder with eventual parole eligibility, or guilty of first-degree murder with none. It's worth knowing where this legal standard actually comes from as general historical background, because the insanity defense is one of the oldest continuously used doctrines in Anglo-American criminal law, and understanding its history explains why it's built the way it is rather than some other way. The modern version traces back to an 1843 English case, known as the Emnatin case, involving a man named Daniel Emnatin who, in the grip of severe paranoid delusions, shot and killed a government official's secretary, believing he was being persecuted by the Prime Minister's own political party. He was found not guilty by reason of insanity, and the public and political backlash to that verdict was significant enough that the House of Lords formally convened a panel of judges to define, in writing, exactly when a defendant could be excused from criminal responsibility on grounds of insanity going forward. What came out of that, now known as the Emnatin Rule, asked whether at the time of the act, the defendant was suffering from a defect of reason severe enough that they either didn't know the nature and quality of what they were doing, or didn't know that what they were doing was wrong. That basic formulation, nearly 2 centuries old, is still the backbone of how most American states define legal insanity today, including they appreciate the wrongfulness of their conduct language used in Massachusetts. Some states have modified it over the decades. A small number use a broader irresistible impulse standard that also excuses a defendant who understood an act was wrong but was, due to mental illness, unable to control the impulse to do it anyway. Others use the American Law Institute's Model Penal Code test, a slightly softer standard than Emnatin's strict knowledge requirement, and a handful of states, most notably following the public backlash to the 1982 acquittal of John Hinckley Jr. in the attempted assassination of President Reagan, have abolished the traditional insanity defense altogether in favor of a narrower guilty but mentally ill verdict, which still results in a criminal conviction but directs the defendant toward psychiatric treatment within the prison system rather than outright acquittal. Massachusetts has kept a version much closer to the original Emnatin framework than many states, which is part of why Lindsay Clancy's defense is legally structured the way it is, arguing not that she is blameless in some everyday moral sense, but that she meets a centuries-old, deliberately narrow legal threshold that has survived nearly 200 years of public controversy precisely because lawmakers again and again have concluded that some subset of defendants genuinely cannot be held criminally responsible in the way the law otherwise demands. A criminal defense attorney named Matt Tempanek interviewed about this case, someone who grew up not far from the actual courthouse and has spent years practicing criminal law, though with no direct role in this trial, offered a piece of local context worth including before we get to his broader legal read on the case, because it says something about the setting all of this has unfolded in. He grew up in Plymouth itself, close enough to the courthouse, he said, that his childhood home was maybe 6 miles from where this trial is now taking place, and he lived there for the first 25 years of his life before eventually relocating to Florida. Asked to describe the area for anyone unfamiliar with the South Shore of Massachusetts, he walked through a quick piece of regional history. When the Pilgrims founded Plymouth in 1620, some of the original settlers eventually moved on and founded Duxbury roughly 15 to 20 years later, one town over. Today, he described Duxbury, along with neighboring Cohasset and Hingham, as among the most affluent towns on that entire stretch of coastline, the kind of place, he said, where he could tell you stories all day, and offered one as an example. A family in the area once built a second staircase in their home for their own children, specifically so the kids wouldn't have to interact with each other while walking up and down the stairs. That's Duxbury, he said, in a nutshell, not the setting most people picture when they imagine a triple homicide, and part of what made this case, in his words, feel so far outside what anyone expected from that particular zip code. It's the same idyllic old New England image most people passing through on the way to Cape Cod would recognize, beautiful, quintessential, historic, and about as far from the popular image of where something like this happens as anywhere in the state, which is exactly why it kept coming up unprompted in conversation after conversation about this case. It's worth naming, as general background on true crime media more broadly, a documented pattern researchers and media critics have studied for years. Cases involving affluent, majority white communities and photogenic, professionally successful families tend to receive dramatically more sustained national media coverage than statistically comparable cases involving less affluent families or communities of color, a phenomenon sometimes referred to in academic and journalism circles as missing white woman syndrome, originally coined to describe disparities in missing persons coverage, but since applied more broadly to true crime media attention generally. This case's setting: a labor and delivery nurse, a husband working a stable professional job, an expensive coastal town most people only know from postcards and Cape Cod road trips, almost certainly plays some role in why it captured this much national and even international attention as quickly as it did, alongside the genuinely unusual and tragic facts of the case itself. That's not a criticism of anyone covering this case, including this video. It's a pattern worth being aware of as a media consumer generally, because it means the sheer volume of coverage a case receives is not, on its own, a reliable measure of how unusual, how significant, or how representative that case actually is of anything beyond itself. With that context established, Tim Panic made a point about why this theory versus reality gap tends to open up so wide in cases like this one. Every high-profile case, he said, draws content creators looking to build an audience around some alternate angle, because straightforward, source coverage of an already tragic case doesn't generate the same clicks that a fresh, unproven theory does. He put it plainly, having practiced criminal law for years, he said he was genuinely not surprised by any of it, because every single case with significant publicity draws content creators looking to push some version of a conspiracy, simply because that's what generates clicks and revenue. He named two other recent, heavily covered Massachusetts cases specifically as examples of the exact same pattern: the Karen Reed case and the Richard Delisle case, pointing out that both had generated their own sprawling online ecosystems of alternate theories almost immediately after achieving national attention, in each instance running well ahead of, and largely disconnected from, whatever was actually being argued inside the courtroom itself. His point wasn't that every theory generated around a high-profile case is automatically false. It's that the emergence of alternate theories has become a near-universal, predictable byproduct of any case reaching a certain level of visibility, regardless of the specific facts involved, which means the mere existence of a swirling theory ecosystem around this case tells you nothing on its own about whether any particular theory inside it happens to be true. It's a pattern now, not a signal. His read on why Lindsay's own defense team hasn't pursued any theory implicating Patrick, despite every incentive to do so if there were real evidence to support it, was blunt. A defense attorney with a plausible alternate suspect and a client facing a murder charge has every professional reason to raise that alternate theory in court, because doing so could get an acquittal. The fact that Lindsay's own legal team, one of the more respected criminal defense practices in the Commonwealth, has never once suggested Patrick had any involvement is, in his view, close to conclusive on its own, the kind of silence that, in a courtroom this heavily scrutinized by both a skilled prosecution and a skilled defense, would be almost impossible to maintain if there were actually something real sitting underneath it. If there were a real, provable alternate explanation available to the defense, it would be sitting inside the actual trial strategy, not left for anonymous commenters to assemble from security camera stills, and the specific silence of a defense team with this much on the line in a case this closely followed is about as strong a piece of negative evidence as this kind of theory is ever going to get. It's worth understanding, as general background, why that particular defense team's silence on the matter carries real weight. Lindsay Clancy is represented by Kevin Reddington, described by people who followed this case closely as one of the more effective criminal defense attorneys in the Commonwealth, someone who, over the course of this trial, has repeatedly taken witnesses called by the prosecution and, through cross-examination alone, drawn out testimony that ended up cutting in the defense's favor rather than the prosecution's. That's a specific, difficult courtroom skill, not a given in every trial, and it's part of why this case has been so closely watched by other attorneys as well as the general public. A defense attorney with that level of skill, representing a client facing a murder charge, examining every witness the prosecution puts up, would have every professional reason imaginable to introduce reasonable doubt about an alternate suspect if the facts supported it even loosely. That's not a moral choice, it's the entire job. The complete absence of that argument from a defense team with both the skill and the incentive to make it if it existed, tells you something the online theories can't. He also spoke in that same interview about Patrick's own mother, Lindsay's former mother-in-law, who testified as a defense witness. It's a detail worth sitting with regardless of what conclusion you eventually draw about this case, because it cuts against the easiest possible reading of the family dynamics here. This is a woman whose 3 grandchildren were killed by her son's wife. She would, by any reasonable measure, have every emotional justification imaginable to want to see Lindsay held fully accountable, to want nothing to do with softening how a jury sees her. Instead, she testified for the defense, describing Lindsay as someone who had, in the period before the killings, been actively reaching out for help, who had been overmedicated, and who had not, in her observation, been herself. It doesn't resolve the case on its own. Grief affects people in wildly different, sometimes contradictory ways, and one relative's testimony is one relative's testimony, not a verdict. As general background on grief psychology, researchers who study families affected by this specific brutal kind of loss, where the person responsible for a death is also someone the surviving family loves, and in this instance is also the mother of the very grandchildren who died, describe it as an especially disorienting form of grief, sometimes called disenfranchised or complicated grief, precisely because it doesn't fit any of society's more familiar scripts for mourning. There's no single socially agreed upon way to grieve a grandchild while also still loving the person responsible for that grandchild's death, and family members navigating it often describe feeling judged from multiple directions at once, too forgiving in the eyes of some, disloyal to the deceased in the eyes of others, regardless of what they actually choose to feel or say. None of that resolves the legal question in front of the jury. It does explain why a single relative's testimony, delivered under oath in a courtroom, can carry so much emotional weight without carrying the same evidentiary weight as forensic or expert testimony. It's a genuine, complicated human position being spoken aloud, not a data point being entered into evidence. But it is a genuinely striking data point, and it's one that gets almost no attention in the online version of this story, which tends to focus entirely on the security camera footage and almost never on who chose to stand up in that courtroom and speak for the woman who killed their grandchildren. The reporter who has covered this trial from the beginning has said, in her own reflections on covering it, that Sue Clancy's testimony was one of the moments that landed hardest for her personally, not because of any single dramatic line, but because of what it asks anyone watching to imagine, your own in-laws testifying either for you or against you, in the exact circumstance that ended your marriage and your family in the worst possible way. That's not a legal observation, and it doesn't resolve anything about guilt or responsibility. It's an emotional one, and it's part of why this case has resonated so far beyond the courtroom it's actually being decided in, because underneath the timeline disputes and the expert witnesses, there's a genuinely universal terrifying question sitting at the center of it. What happens to the people left standing around a tragedy like this, the ones who have to keep loving the people involved or keep showing up for them, even when the rest of the world has already decided how it feels about them? That same reporter has described the scale of public interest in this case as something she genuinely didn't anticipate going in, despite having followed it closely since the children died in January of 2023. She said she expected to be preparing herself professionally for the difficult substance of the case, the medical and psychiatric detail, the graphic specifics that come with any trial like this, but not for the sheer reach of the public conversation around it, describing requests to appear on programs as far away as Ireland to discuss a case unfolding in a single county courthouse in Massachusetts. That's worth sitting with for a second because it says something about how thoroughly geography has stopped mattering to which stories capture public attention. A trial in Plymouth County, covered by a live stream and a handful of dedicated reporters, can now generate genuine international interest within days, in a way that would have been almost unthinkable for a case of this size a generation ago, when a story's reach was largely set by which newspapers and broadcast affiliates chose to run it, and how far their physical distribution or signal happened to extend. There's one more thread worth pulling before we get to where this case stands today, and it involves money because money has a way of complicating even the most sincere grief, layering financial stakes on top of loss in a way that can make even well-intentioned decisions look, from the outside, like something more calculated than they actually are. Patrick Clancy has a pending civil lawsuit against the hospital system and medical providers who treated Lindsay in the period before the killings, alleging failures in how her mental health crisis was managed. That lawsuit exists entirely separately from the criminal trial, but the criminal defense attorney interviewed for this case raised an interesting, if speculative, financial dimension to it worth including as context, clearly labeled as his own theory rather than established fact. If Lindsay is ultimately found not criminally responsible by reason of mental disease, it may become significantly harder for the hospital system's own legal defense to argue that her mental state wasn't a serious, foreseeable medical failure on their part, potentially strengthening the very civil case Patrick has filed against them, and making a large settlement more likely rather than a full, drawn-out civil trial that would force far more of the medical record into public view than has surfaced so far. It's a reminder that even in a case this emotionally devastating, there are financial incentives running in the background that have nothing to do with guilt or innocence, and everything to do with how institutions manage their own legal exposure once a tragedy becomes a lawsuit. As general background on how a civil medical malpractice claim like Patrick's actually works, separate from anything specific to this case, a plaintiff generally has to establish 4 things to prevail: that the provider owed the patient a professional duty of care, that the provider breached that duty by falling below the accepted standard of care for their field, that the breach actually caused the harm being claimed, and that real, calculable damages resulted from it. In a case involving a missed or mismanaged mental health crisis, that typically means expert witnesses on both sides arguing over what a reasonably careful obstetric or psychiatric provider should have caught, documented, or escalated given the specific symptoms and history in front of them at the time. A fundamentally different, more slow-moving, more privately negotiated process than a criminal trial, usually resolved through settlement long before it would ever reach a public civil jury verdict, precisely because hospital systems and their insurers have strong incentives to avoid the reputational and financial cost of a public trial when the underlying facts are genuinely unfavorable to them. That's part of why, as mentioned earlier, a large settlement is often the more likely outcome in cases like this than a drawn-out civil trial, not because the underlying claims are weak, but because institutions with deep insurance coverage typically prefer negotiating quietly to litigating publicly once the facts already look bad in the court of public opinion. There's a second legal process worth understanding here too, because it comes up constantly once not criminally responsible verdicts are discussed online, usually inaccurately. What actually happens to a defendant found not criminally responsible by reason of mental disease? It is not, contrary to a very common misconception, a walk-free scenario. In Massachusetts, as in essentially every state with a similar standard, a defendant found not criminally responsible is committed to a secure state psychiatric hospital, typically for an initial evaluation period, and release from that commitment is not automatic or guaranteed at any fixed date. It requires periodic court review, ongoing psychiatric evaluation, and a formal judicial finding that the person no longer poses a danger to themselves or others, a standard that in practice can keep someone committed for years, sometimes longer than an equivalent prison sentence would have run, precisely because release depends on demonstrated clinical stability rather than the passage of a fixed calendar term. Andrea Yates, the case referenced earlier as general historical background, remains under psychiatric commitment more than 2 decades after her original offense, having never been released to the general public. That's the actual legal and practical reality behind a not guilty by reason of insanity outcome. An indefinite, closely supervised psychiatric commitment with an uncertain endpoint, not the courtroom drama cliché of someone walking out the front door. It's also worth knowing as general background what happens on the other end of the outcome spectrum, if Lindsay Clancy is instead convicted of murder. Every criminal defendant convicted at trial in Massachusetts retains an automatic right to appeal, and in first-degree murder cases specifically, the Commonwealth's highest court, the Supreme Judicial Court, is required by law to conduct its own independent review of the full trial record, a broader review than an ordinary appeal, specifically because of how severe a first-degree murder sentence is. That review can result in a conviction being affirmed, reduced to a lesser charge, or in rarer cases overturned outright and sent back for a new trial, which is exactly what happened as mentioned earlier in Andrea Yates's case, where an appellate court found a genuine factual error in expert testimony serious enough to undo the original conviction. That possibility exists here too in either direction, regardless of which way this particular jury eventually rules, which is part of why the standard both sides are being held to throughout this trial matters as much as it does. A verdict reached through a process substantial legal errors later on appeal is not actually the end of a case. It's simply the next stage. A case this complex, this closely watched, and this legally layered would be expected to pass through either way. Lindsay Clancy herself has, in fact, already been under this exact kind of secure psychiatric care since shortly after the killings. She's been hospitalized at Duxbury State Hospital, one of the Commonwealth's designated secure psychiatric facilities, for the 2.5 years leading up to and through this trial, which gives a concrete, present-tense picture of what a not criminally responsible outcome would functionally continue rather than newly create. Not a release but a continuation of exactly the kind of closely supervised institutional care she has already been living under since the immediate aftermath of that January evening. Here's where things actually stand as of this week, because this trial has moved fast in its final stretch and it's worth updating the record rather than leaving you with where it stood a month ago. The defense rested its case this past Friday. Its final witness was Dr. Philip Resnick, a forensic psychiatrist, who testified that Lindsay experienced what he described as command hallucinations, a voice or an external force she reported as having taken over her body and directed her actions, and who characterized what happened not as an act of hostility toward her children but as what he termed altruistic filicide, a recognized, if devastating, clinical framework in which a parent in the grip of psychosis comes to believe, however wrongly, that they are protecting a child from a worse fate by ending their life. It's worth knowing as general background that this specific term isn't something invented for this trial. It comes directly from a landmark, still widely cited 1969 academic paper on filicide that established a formal classification system for the different psychological motives behind a parent killing a child, dividing cases into categories including altruistic filicide, acutely psychotic filicide, unwanted child filicide, accidental filicide arising from abuse, and spousal revenge filicide. That classification system has functioned as a foundational reference point in forensic psychiatry for more than 5 decades, used by clinicians and courts across the country to help distinguish, as precisely as the science allows, between fundamentally different kinds of cases that can otherwise look superficially identical from the outside, a parent and a dead child, but that stem from entirely different psychological mechanisms, each with different legal and clinical implications. Invoking that specific established category isn't a rhetorical flourish meant to soften what happened. It's a credentialed expert placing this specific case within a decades-old, peer-reviewed diagnostic framework that predates this trial by more than 50 years. That's the clearest, most complete version of the defense's actual theory of the case, delivered by their own final expert witness, and it's a useful thing to have in front of you instead of a second-hand paraphrase of it. The prosecution didn't let that stand unanswered. Their rebuttal witness, psychiatrist Dr. Avram Mack, testified this week that in his clinical assessment, Lindsay was suffering from major depressive disorder in the period leading up to the killings, real, serious but distinct from psychosis, and that she knew what she was doing was wrong at the time she did it. As part of that testimony, Dr. Mack pointed to something concrete. Lindsay had driven one of her children to a doctor's appointment just hours before the killings, which he offered as evidence of someone functioning with intact, organized judgment, not someone in the middle of a psychotic break. That cross-examination got heated. Defense attorney Kevin Reddington pressed Dr. Mack hard on his own clinical reasoning around postpartum psychosis, and at one point after the doctor appeared to smile on the stand, Reddington snapped at him directly. "What are you smiling for? This is not funny, sir." It's a small moment, but it's a genuinely human one to end this update on. A defense attorney who has spent weeks, by this point, sitting a few feet from a client he's watched relive the worst night of her life over and over, on cross-examination after cross-examination, snapping at a witness for what read, in that instant, as a lapse in the gravity the moment demanded. Courtroom transcripts don't usually capture tone, but that exchange is a reminder that everyone in that room, the attorneys, the jurors, the reporters, the family members sitting in the gallery, has been living inside this case's specific sustained weight for over a month straight, not just absorbing it in the same digestible half-hour chunks the rest of us have had the option to watch it in. It tells you something real about the temperature in that courtroom right now, this many weeks in, with both sides' entire case resting on two credentialed experts who examined the same set of facts and arrived at opposite clinical conclusions, which is, in the end, exactly the kind of genuine good-faith disagreement a jury is asked to resolve in a case like this, not evidence that either side is lying, and it's a genuinely useful thing to keep in mind the next time a piece of expert testimony gets flattened online into a simple gotcha against the other side's case, when the fuller reality is almost always two trained professionals disagreeing in good faith about a genuinely hard clinical question. It's worth understanding as general background why criminal trials routinely end up with this exact dynamic, two credentialed experts examining the same underlying facts, reaching opposite conclusions, because it's one of the more frequently criticized features of how the American legal system handles specialized, technical questions like psychiatric diagnosis. Unlike a treating physician, who only has one patient and one job, figuring out what's actually wrong with the person in front of them, a forensic expert witness is typically retained by one side of a legal dispute specifically to evaluate the evidence and offer an opinion that side finds useful to its case. That doesn't automatically make either expert dishonest. Forensic psychiatry is a legitimate, credentialed subspecialty, and experts on both sides of a case like this one have to reach their conclusions in ways that will hold up under aggressive cross-examination from a skilled opposing attorney, which imposes real professional discipline on the process. But critics of the system, including plenty of judges, legal scholars, and psychiatrists themselves, have long pointed out that when each side handpicks its own expert, from a pool of professionals who are, by the nature of the job, more likely to be retained again in the future by whichever side they tend to agree with, it can start to look less like impartial science being presented to a jury and more like two paid advocates dressed in the language of medicine. That's not a criticism unique to this trial. It's a structural feature of the adversarial system itself, and it's exactly why the burden of proof, the standard jurors are instructed to apply, and the jury's own independent judgment matter as much as they do, because in a case built on dueling expert testimony, the jury isn't just deciding who's more likable on the stand, they're being asked to do something genuinely difficult, weigh two competing professional opinions against each other and decide which one actually fits the fuller record better. As of right now, prosecutors were expected to call additional rebuttal witnesses before both sides moved to closing arguments, which are anticipated to begin this week, with jury deliberations to follow shortly after. So by the time you're watching this, it's entirely possible the jury already has the case in their hands, or depending on when you're catching this video, a verdict may already exist. We'll update you the moment it does. What won't change regardless of which way that verdict goes, is everything we've just walked through, the actual testimony, the actual timeline, and the actual sourced reality behind every theory that's tried to turn this into something other than what the record itself shows it to be, a record that, for all its genuine complexity and all the real unresolved ambiguity sitting inside it, has never actually pointed toward any of the alternate explanations that have spent 2.5 years competing with it for the public's attention. It's worth knowing, as general background, roughly what happens procedurally between now and an actual verdict, because a lot of viewers understandably assume closing arguments lead almost directly into a jury's decision. They don't. After both sides deliver their closing arguments, the judge delivers formal jury instructions, a detailed, often lengthy explanation of the exact legal standards jurors are required to apply, read aloud in open court and typically provided to the jury in writing as well, covering everything from the elements of first and second-degree murder to the specific legal definition of criminal responsibility discussed earlier in this video, including which side carries the burden of proof on which question. Only after receiving those instructions does the jury retire to begin actual deliberations, which can run anywhere from a few hours to multiple days depending on the complexity of the case and how quickly or slowly jurors are able to reach consensus. In Massachusetts, as in nearly every state, a criminal verdict must be unanimous. All 12 jurors have to agree on each individual charge before a verdict can be returned. If they can't reach unanimous agreement after a genuine, sustained effort, the result is a hung jury and a mistrial on whichever charges remain deadlocked, which would leave prosecutors to decide whether to retry the case in front of an entirely new jury rather than the case simply ending. Given the complexity of what this specific jury has been asked to weigh, not just whether Lindsay Clancy did this, which isn't contested, but a genuinely difficult clinical and legal judgment about her state of mind in a specific window of time 2.5 years ago. Deliberations here could reasonably take longer than a more straightforward case, and that's worth keeping in mind if the wait between closing arguments and an actual verdict stretches out longer than you might expect. If you've made it this far, you already know this isn't a case with a tidy ending, at least not yet. Closing arguments are only now getting underway, and no verdict has been reached. That unresolved quality is part of what makes it so hard to stop thinking about once you start, and part of why so many people have kept coming back to this case week after week, looking for an ending it hasn't given them yet. Before we get to how the jury itself is being kept insulated from everything we've just spent the last half hour walking through, it's worth taking a breath and remembering why any of this matters beyond the spectacle of it. 3 small children, Cora, Dawson, and Callan, are dead. A mother who spent her professional life helping other families welcome their own children into the world, year after year, shift after shift, is now paralyzed on trial, and will likely spend whatever verdict comes down carrying the weight of what happened in that house for the rest of her life, whichever direction that verdict goes, and will keep carrying it long after this trial has stopped being anyone else's headline, long after the theories have moved on to whatever case captures the internet's attention next. A father lost his children and by every honest reading of the record appears, by every measure a courtroom actually recognizes, to have done everything right in the moments and years since, cooperating fully with police, testifying under oath about the most painful details of his life, and still finding himself at the center of theories accusing him of having done the unthinkable himself, theories built by people who will never have to look him in the eye and defend them. It's worth sitting with what that specific position actually requires of a person, because it doesn't get much attention next to the more dramatic threads in this case. The doppelganger clips and the shoe-sole comparisons get the views. The quieter, unglamorous fact of a father showing up again and again to answer for a night he didn't cause gets almost none. Patrick Clancy has had to sit through and answer questions about the death of all 3 of his children in public on camera more than once, first for investigators, then in pretrial proceedings, then again on the stand in this trial, under cross-examination from a defense attorney whose job is specifically to probe every soft spot in his account, a level of scrutiny he has never once been permitted to escape, no matter how consistently the underlying facts have held up under it. He has done this while also, by his own legal filings, pursuing a separate civil case over what he believes were missed opportunities to prevent this, a lawsuit that requires him to keep revisiting the same painful medical history all over again in an entirely separate legal arena. And while an entire online audience has spent 2.5 years building theories that recast him as a suspect rather than a survivor, a role reversal no camera-verified alibi has ever managed to fully undo in the minds of people determined to keep it alive. Whatever you make of the actual case, it's worth remembering that the theories examined in this video aren't abstract internet content to the person they're about. They're accusations, made about the worst night of his life, by people who have never sat through a single hour of the testimony he's had to sit through in person, more than once, from a courtroom seat he did not choose and cannot simply get up and leave. None of that is content. It's a family that no longer exists in the form it used to, and it's worth holding on to that fact underneath every procedural detail, every timestamp, and every expert opinion we've covered. It's worth adding some general background here on what happens to the wider circle of people around a tragedy like this one, because the emotional toll doesn't stop at the 2 people whose names are on the case caption. Grandparents, siblings, co-workers, neighbors, the first responders who walked into that basement. All of them carry some version of what mental health researchers call secondary or vicarious trauma, a real documented psychological impact that can affect people who witnessed, responded to, or are closely connected to a traumatic event without having caused or directly experienced it themselves. First responders in particular are a population researchers have studied closely on this front, precisely because their jobs regularly expose them to exactly this kind of scene, and departments increasingly build informal peer support and counseling resources for officers specifically because of it. A real, practical acknowledgement that walking into a basement, and finding what those 2 officers found in this case, leaves a mark that doesn't disappear once the report is filed. None of that is a detail specific to this case, and no claim is being made here about how any specific person involved has or hasn't been affected. It's included because it's easy, watching a trial from home, to think of a tragedy like this as bounded entirely by the 4 walls of that house and the handful of names that keep coming up in testimony, when in reality, the actual circle of people carrying some piece of this is almost always much wider than what makes it into any single hour of courtroom coverage. The jury deciding all of this, notably, has been sequestered from almost everything we've just discussed. They are not permitted access to social media during the trial. They are instructed not to read local newspaper coverage. If a juror's own family member happens to mention something they saw online, a theory, a headline, a clip, the juror is required to disclose that to the court rather than absorb it quietly. That means the entire conspiracy theory ecosystem we've spent the bulk of this video walking through. The doppelganger claims, the corrupt investigation claims, the DA's office house claims, exists almost entirely outside the actual trial. It's worth understanding as general background what jury service in a trial of this length and intensity actually asks of an ordinary person, because it's easy to lose sight of the fact that these are 12 private citizens, not legal professionals, pulled out of their regular lives for weeks at a time. Sequestration in a high-profile case typically means jurors are housed together, away from their families, often in hotel accommodations arranged and paid for by the court, with their access to phones, television, and internet either removed entirely or tightly monitored for the duration of the trial. A genuinely disruptive, isolating experience layered directly on top of the emotional weight of the testimony itself. Courts generally screen prospective jurors extensively before seating them specifically to identify and exclude anyone who couldn't set aside pre-existing exposure to a case this widely covered. And the jurors who remain are asked, for weeks, to hold an enormous amount of graphic, difficult material in their minds without being able to discuss it with a single person outside the other 11 people sitting beside them in that jury box. Not a spouse, not a close friend, not even, in many cases, each other outside of formal deliberations. Whatever this jury ultimately decides, it's worth acknowledging plainly that 12 ordinary people have just spent weeks doing something genuinely difficult, under real personal strain, so that the rest of us don't have to be the ones deciding it. As general background on why courts insist on this, a verdict reached by jurors who were exposed to outside theories, unverified claims, or media speculation is genuinely vulnerable to being overturned on appeal, because a defendant is constitutionally entitled to a verdict based only on evidence properly admitted in that courtroom, tested through cross-examination, not on whatever a juror happened to scroll past the night before. That's not a technicality for lawyers to argue about after the fact. It's the actual mechanism that protects the reliability of the outcome, for both sides, regardless of which way the eventual verdict goes. It's also why, if you're watching this case from the outside and forming your own opinion about the theories we've covered today, you're doing something meaningfully different from what that jury is doing. Not a lesser version of the same task, and not one that entitles anyone watching from home to a verdict of their own that carries the same weight as the jury's, a fundamentally different one, built on a fundamentally different, much noisier set of inputs than the 12 people actually deciding it are allowed to have. It's worth being honest about what that actually means for a video like this one too, rather than exempting it from its own point. Everything covered here, however carefully sourced, is still a second-hand account, assembled after the fact from testimony filtered through reporters, clipped and reorganized for a format built to hold your attention for roughly the length of this video rather than the actual weeks this trial has run. That doesn't make it worthless. A careful second-hand account, built on primary sources and checked against them, is a genuinely useful way to understand a case you can't sit through in person. But it's a different, lesser thing than the actual trial record itself, and it's worth remembering that distinction the next time any video, including this one, tells you with total confidence what a piece of testimony definitely meant. The 12 people who will decide Lindsay Clancy's fate are working from a much narrower, much more disciplined set of information than anyone watching this from home. Sworn testimony, physical exhibits, expert opinion, and the judge's instructions on the law. They have, effectively, 2 questions in front of them, not the dozen the internet has generated. Did Lindsay Clancy commit these killings? A fact her own defense does not contest. And separately, was she, at that specific moment, suffering from a mental disease or defect severe enough that she could not appreciate the wrongfulness of what she was doing? It's worth restating that second question in slightly different terms one more time, because it's easy for it to blur together with a more general, more emotional question the internet keeps asking instead. Not was what happened understandable, and not does she deserve sympathy, but a narrower, more clinical inquiry. In the specific window of time she committed these acts, had a diagnosable mental illness impaired her capacity to know that what she was doing was wrong, to the degree the Law requires. Those are different questions, and conflating them is exactly how a lot of the online discourse around this case has gone sideways, treating the insanity defense as a referendum on how much compassion the public is willing to extend to Lindsay Clancy as a person, rather than as the narrow technical, legal, and clinical determination it actually is. The jury isn't being asked whether they feel sorry for her. They're being asked whether the Commonwealth has proven beyond a reasonable doubt that she was capable of understanding right from wrong in that specific window, a question with a real evidence-based answer sitting somewhere inside the testimony we've spent this entire video walking through, whether or not that answer turns out to be a comfortable one. Everything else, every theory about Patrick, every theory about a homeowner, 2 owners removed from the tragedy, every theory about fake journal entries, is, as far as the actual 12 people who matter are concerned, simply not part of the case, no matter how large a share of the public conversation around it they've come to occupy. There's a real difference, worth naming directly, between the court that will decide Lindsay Clancy's legal fate and the other court this case has been tried in for the last several months, the court of public opinion. That second court has no jury instructions, no rules of evidence, no sequestration, and no requirement that anything presented in it actually be true. It runs entirely on engagement, and engagement rewards drama over accuracy every single time. That's not a criticism of any one viewer or commenter. It's simply how these platforms are built, and it's worth being conscious of every time a case like this crosses your feed. The 4 theories we've walked through today aren't equally weighted in how much genuine ambiguity they contain. The timeline discrepancy is real and worth understanding, even though the physical logistics ultimately make an alternate Patrick theory almost impossible to square with the clock. The doppelganger theory is built on interpreting low-resolution security stills, and has never been raised by anyone with actual access to the full, high-quality footage and chain of custody. The corrupt investigation theory ignores a documented, cooperative, camera-verified alibi, save for one genuinely unexplained detail about a handful of pills. The homeowner theory collapses the moment you line up the actual dates. And the fake psychosis theory has to somehow explain away not just the defense's own psychiatric witness, but the sworn testimony of the one person who arguably knew Lindsay Clancy best in the weeks before this happened, her own husband, called by the prosecution, describing a wife who had already told him she was having thoughts she couldn't control. None of that resolves the actual, difficult legal question still sitting in front of that jury. Was Lindsay Clancy, in the moment she killed her own children, capable of understanding what she was doing was wrong? That is not a question this video or any amount of online theorizing is equipped to answer. It's a clinical legal judgment that requires weighing expert testimony most of us will never fully have access to, delivered by people trained specifically to make that kind of determination, and it belongs to 12 jurors who have sat through testimony far more detailed than what we've been able to cover here. What this case actually offers, once you strip away the theories built to keep you scrolling, isn't a mystery to be solved. It's a genuinely tragic collapse, a young mother, a nurse who spent her career helping other families, sliding into a mental health crisis that the people around her, including trained medical professionals who evaluated her directly, did not fully catch in time, with 3 children paying the ultimate price for a system, a marriage, and a mind that all failed to hold together in exactly the moment it mattered most. We started this video standing on a dark porch in Duxbury with a trooper, a flashlight, and 2 figures he couldn't yet identify. It's worth ending back there for a moment because everything covered in between, the timeline math, the shirt colors, the pill bottles, the search history, the century of legal history behind an insanity defense, the jury sequestered from all of it, exists to answer one basic honest question: what actually happened and what does the record actually say about it, as opposed to what feels true after watching a 2-minute clip. That trooper didn't know in that moment what he was walking toward. Neither did the officer who crossed paths with a man moving fast and silent near a bulkhead door. Neither, in a real sense, do any of us watching this case unfold from a screen 2.5 years later. We're all still, in our own way, walking toward that basement, trying to understand what we're about to find. The difference between doing that responsibly and doing it the way most of this case has been handled online comes down to something almost embarrassingly simple: reading the whole thing, not just the part that confirms what you already suspected. If there's one thing worth taking away from everything we've walked through today, it's this. The 4 words Patrick Clancy screamed in that basement, "She killed the kids," were true the moment he said them, and they remain true today. Lindsay's own defense has never argued otherwise. What those 4 words were never equipped to explain, and what an entire internet's worth of theories has spent 2.5 years trying and failing to substitute for, is why. That answer, if it exists at all in a form any of us could actually understand, is sitting somewhere inside a courtroom in Plymouth County, in testimony from doctors, nurses, police officers, and a grieving family being weighed right now by 12 people doing something almost nobody online is willing to do. Withholding judgment until they've actually heard the whole thing, a genuinely small, unglamorous discipline, and also, turns out, the entire difference between understanding a case like this one and merely having an opinion about it. There's a reasonable chance this case ends up mattering beyond its own verdict, regardless of which way that verdict goes. And it's worth naming that as a closing thought rather than leaving it unsaid. High-profile cases involving postpartum psychosis have, historically, been followed by real, measurable shifts in how seriously hospitals, insurers, and lawmakers treat maternal mental health screening. Not because any single case changes the law on its own, but because sustained public attention tends to create political and institutional pressure that quieter, less publicized failures never generate. Whatever the jury in Plymouth County ultimately decides about Lindsay Clancy's own criminal responsibility, the underlying clinical reality this case has forced an enormous number of people to learn about for the first time, that postpartum psychosis is real, that it can be nearly invisible to trained professionals in short clinical encounters, that it can escalate with terrifying speed, and that the people experiencing it are very often desperately trying, in whatever broken way they can, manage to signal that something is wrong, is not going away once this trial ends. If even a fraction of the people who followed this case walk away from it able to recognize those warning signs in a friend, a partner, or themselves and reach for help faster because of it, that's a real, if small and imperfect, thing to come out of an otherwise unrelentingly tragic story. Not a redemption of it, nothing could be, but a small, honest thread of use pulled out of a story that otherwise offers almost none. There's a reason so many people have followed this specific case together rather than quietly, on their own. And it's worth naming honestly before we close this out. Cases like this one tend to generate real communities of viewers, people who show up in comment sections, in group chats, in family conversations, comparing notes on the same testimony, arguing gently or not so gently about the same open questions, checking in on each other's read of a new development the way people once gathered around a single shared broadcast. That collective processing is, in its own way, a genuine response to something genuinely hard to sit with alone. A group of strangers working through the same difficult material together, even if some of that working through takes the shape of theories that don't hold up once you actually check them. The instinct underneath it, wanting to understand, wanting to talk it through with someone else who's also paying attention, isn't the problem. It's actually a healthy one. The only thing worth changing about it is making sure the conversation you're having is built on the actual record, rather than on whatever version of it traveled the fastest and the farthest online. We'll be following this trial as it heads toward its own conclusion, and if you want to be here when the verdict actually comes down, not the version filtered through a 2-minute clip but the real one, subscribing means you'll see it the moment we cover it, straight from the record, the same way we've done every case on this channel. Thanks for spending this time with a genuinely difficult story, and for reading past the headline version of it to get here. Cases like this one deserve that kind of patience, even when, especially when, it would have been easier to just take the 2-minute version and move on. We'll see you in the next one.